May I please, Your Lordship?
Yeah.
So with the consent of other side, I beg to mention item number 26 to 28 meter. Also, I pay for 2 weeks adjournment in this case.
2 weeks.
2 weeks, Lord.
The request of non-consent matter is urgent for 2 weeks. These matters are urgent for 2 weeks.
Lost high level.
May it be lordships. My lord, in item number 22, there is one correction, my lord. So,
Item number 22, PIL.
PIL, yes.
Yes, what do you want?
My lord,
What do you want?
there is a correction, my lord. There typographical mistake.
1 week? How much time?
On Monday, Thursday. We'll have the application today. But
After a week, at the request of non-consent application list after a week.
available.
May I please, Lordship? Lordship, item number, I beg to mention item number 19.
19.
19. The connecting council is out of station, Lordship. Connecting council is out of station.
Have you informed the other side?
Yes, Lordship.
This is the surface proceedings.
Sorry,
Surface proceedings you are challenging.
Lordship, I'm not in this case, Lordship.
After a week,
Obliged, Lordship.
May I please your lordship, with the consent of the other side, I beg to mention item number 35 and 36. My senior could not appear today due to serious illness of his mother. So the matter may be taken up after 1 week.
2 weeks.
Highly obliged.
May I please, your lordship? Lordship, I beg to mention item number 34.
34, yeah.
34. Lordship, in this matter, the respondent have filed the affidavit in opposition on 13th of this month. I pray for 2 weeks time to file my reply.
Then consent for the petitioner has submitted that. The respondent has filed rejoinder or reply,
Reply.
filed reply in counter. Recently, he wants to file rejoinder to. So he prays for adjournment. But it is adjourned 2 weeks.
Obliged, lordship.
May it please your lordship. I beg to mention item number 40, my lord.
40.
40. In this matter, my lord, we have challenged a rule, my lord, requiring recruitment for, my lord, TET from recruitment test. We have already done our TET. We have challenged that rule, but yesterday my learned senior handed over me a copy. That rule has been amended. So we have now have to challenge the amended rule. So, my lord, may I pray,
Withdraw this,
my lord?
withdraw with liberty to.
Yes, my lord. My prayer is to withdraw to liberty to challenge the amendment rule.
Okay, learned concept of the petitioner has submitted that in view of the fact that the rules have been amended. He wants to withdraw this petition with liberty to file fresh if so, if it requires so. Dismiss with liberty as prayed for.
Right. Deeply obliged.
Obliged.
Lordship, may I pray for the listing of 2 interlocutory applications for orders, Your Lordship? The main appeals are listed tomorrow, Your Lordship.
Tomorrow.
May I please, your lordship? I'm also praying for listing of a IA lordship for modification of order lordship. It may list on 21 lordship, correction of a date lordship. Deeply obliged, lordship.
May I please, your lordship? Lord, I beg to mention a writ appeal, which was actually heard by my lord's predecessor. And my lord, I'm only praying if it can be listed on a particular date. It concerns the seniority, my lord, in PWT.
When you want?
My lord, may I request for either 22nd or 27th of March, my lord?
March?
Outstation, my lord, I'm just requesting.
27th March.
Obliged.
Please, your lordship. I'm praying for listing of a fresh writ appeal on Wednesday, my lord. This is a challenge to a particular clause of tender by which we have been ousted by an experience clause. Now, my lord, the work orders are to be issued anytime, my lord. That's why the urgency.
Thursday.
May I also request for a listing of a PIL, my lord? It concerns water supply in the city of Guwahati, my lord. In fact,
Is it already pending?
it's pending, my lord. In
What's
fact,
the next date?
there's no date, my lord. There's no date. There was a date fixed, which it didn't come up on
Which
that.
date would you like to?
Well, any of these dates, 22nd or 27th.
27?
Obliged, deeply obliged.
For orders, item 1.
May I please your lordship, in relating to this case, lordship, SLP was prepared by the state of Assam lordship, but that SLP is dismissed lordship, so
Pending.
dismissed lordship. So I need some more time to take instruction from the authority, what steps they have taken after dismissal of SLP lordship. 3 weeks lordship. 3 weeks lordship.
Okay, Learned, concept of the respondent government has submitted, then council for the respondent has submitted that the SLP preferred on behalf of the state of Assam before the Honorable Supreme Court has been dismissed. Would stop she pays some time to complete her inspections. This when
After 3 weeks lordship.
just after 3 weeks, as today.
Item number 2.
Lordship, this appeal was filed by the Assam Government Construction Corporation, and it was closed down, Lordship. In this particular case, Lordship, the government has filed an appeal before the Supreme Court. In this case also, Supreme Court dismissed the SLP recently, Lordship. Earlier it was stayed because of this, Lordship. And SLP has been dismissed, Lordship. Now, government has informed that they will take instruction from Lordship. After 3 weeks, Lordship may list this matter.
Okay, it is informed by the consent of the parties that SLP preferred by the state of Assam is already by the Assam Government Construction Corporation
Lordship.
is already been dismissed by the Honorable Supreme Court. Learned concept of the respondent prays for time to complete complete inspections just after 3 weeks as
Obliged.
praised.
Item 3.
My learned friend was to bring instruction.
Lordship,
Last time you were
he is getting less, Lordship. 42% he is getting now, whereas he is entitled to 46%.
he's entitled for 46%.
46%.
So now, what do you suggest? If he is getting less, then
Less, Lordship. 42% he is getting. He is
So
entitled to
now-
46%.
what steps you are supposed to take?
Now it is the ball is in his court, Lordship. We have already sent to the settled.
Many years.
We have already. Settled pension accounting.
No, when did you settle?
He didn't know repeating this. On 26th April 2018. It was 31 August 2015.
No, calculation, you have to send the,
Yes, there is. calculation.
no, you have to send the seal.
Yes, yes. We have sent. This is the calculation. This is the,
No, you have to send the,
yes. Yes, calculation.
when?
Yes, sent is from 2018. Then pay an account of that on 31 August 2020.
Just one second. 26 April.
Yes.
18.
Then 31 August 20.
August 20.
No, that I also, that we have forwarded to the bank.
It's the bank. who is not doing this.
That we have
It is
forwarded
the
to the
bank.
bank.
It is the bank, Lordship, who is, it is the bank who is giving less amount, Lordship. It is the bank.
The bank can give the.
Yes, Lordship. This is my instruction, Lordship. I have been instructed that this is the bank is the authority used to.
Who is appearing for the bank?
I'm appealing for the bank.
Yes, why are you making less payment? Once it is determined that he is entitled for so amount, how you can make a assessment for it?
In Calendar, your lordship, I am taking 1 week time, your lordship. The meantime, I will obtain the instruction. And a copy of this revised calculation will be provided to you.
Yes, you are supposed to. Decay. The net concept of the respondent number 3, state of Assam.
I don't know the copy of the-
Has
Accounting general.
respondent number 3 has made a statement that at present, the petitioner is getting less pension amount. And is the fault of the bank who is paying the less amount, less pension amount. It's from the net counsel appearing for the respondent bank raised for and granted 10 days time to complete his instructions. List after 10 days. It is in a list on so and so. You complete your instructions, you are not. And make it sure all the dues are cleared by the next day.
Much.
One and two.
Item number 4. Lordship, in this case, I prayed another 10 days time to file amendment.
Amended calls, fresh address,
Lordship,
amended address,
Lordship,
decay, when counsel appearing for the appellant, raised 2 weeks further time to furnish the correct and fresh address of the told respondent. List after 2 weeks.
much.
Item number 5.
May it please the Lordship.
Service complete in regard to respondent number 3, not complete in respondent number 4.
One is not completed, but in the given stand of circumstances, my lord, since there was a bifurcation in the department, government department, it was well known to them. Otherwise, they can take the call. And the observation made therein by this honorable court, if Lordship may peruse, that it was almost given in consent. That they are willing to execute it, only difficulty being now that the administration unit has changed. So they may go ahead with that.
Yes,
And I'm referring to page
My lord,
23.
Because in respect of respondent number 4, my lord, I am appearing on behalf of respondent number 2, my lord. The principal of the Silchar Medical College, my lord, who has during his tenure, my lord, he has forwarded the proposal to the government, my lord. Now he has been transferred from there, my lord, on 10th May 2023, my lord. But during his tenure, he has forwarded the proposal to the government, my lord.
so you have whatever you have to, you are required to, you are required to do, you have done that.
Yes, my lord, because on behalf of
Who is the authority used to comply with the order of this court?
respondent number 4, my lord. Now, my lord, the ball is in the court of respondent number 4, my lord.
Number 4 in contempt case.
Yes, my lord.
How many respondents are there? Initially, there were 3. Thereafter, there was a bifurcation in the department during the continuance of the proceeding. Accordingly, it was required that the present incumbent be informed and later added on the party. We did so. It was Health and Family Welfare Department initially. Subsequently, it changed.
As per the office report, service upon the respondent number 4 is not complete. That fresh notice be issued to the respondent number 4. Visits were filed in 2 sets. One set be given dusty to the counsel for the petitioner, other set be sent to registered court with the AD. The notices issued to the respondent number 4 are returnable on 13th of March.
Very well. Obliged. Grateful.
Item 6.
Lordship, I'm appealing for the respondent, your lordship, to this
Respondent
copies.
number 1,
Respondent, sole respondent.
the sole respondent.
Yes, my lord.
Yes.
And the copies have been served today itself, your lordship.
So have you vacated the house or not?
Oh, that has been
Since-
vacated. That has been vacated as per instruction.
When,
And I may confirm also.
huh?
I may confirm also that has been vacated as per instruction.
When you have vacated the, and you have shifted your family to Port Blair,
They
Uh,
were, they
At present, he is
he is
posted there.
vacated.
shifted, yes.
You are for the appellants.
Uplands, my lord.
So when he is vacated there?
My lord, he is in Port Blair right now, my lord. 2021.
This quarter has been vacated or not?
Yes, my lord.
That has been vacated.
Vacated.
Then what remains in this matter?
My lord, the only grievance, we have charged some penal interest, penal rent.
After all, is
That is-
constable, 50,000 you calculated the penal rent.
It's fine.
My lord.
Okay. Except circumstances, once you have vacated the, we are not inclined to.
No, because that will
What
also,
the question involved in this petition may be addressed in some suitable case. Kabhi aayega usme kare?
my lord, we are only on the penal charges which
That's
we had
right.
imposed, my lord, because
That's right. But it appears that the order passed by the Leonard Singhal is quite reasonable. It's
my lord, some amount may be directed to be paid, at least not that much, my lord.
reasonable.
That would be a deterrent. Otherwise, my lord, it will be a precedent for all the other employees. They will also try to.
We'll keep it open to argue in a suitable case. We'll keep it open. Yeah. The matter is regarding vacation of the government accommodation by respondent who is serving as a constable in the CISM. To stop. The respondents have initiated action, the respondent has levied a penalty of around 50,000 or what?
50,000, my lord.
Around 50,000 rupees on the ground that despite the transfer of the respondent, he has not vacated the government accommodation after the period is expired. To stop. The learned single judge, after taking into consideration the relevant policy for vacation of the government accommodation, has made easy the penalty imposed by the appellants on the sole respondent. To stop. It is informed that now the government accommodation occupied by the family of the respondent constable has been vacated. To stop. In view of the subsequent development, we are of the view, we are of the opinion that since the government accommodation has already been vacated by the sole respondent, no further order is required to be passed in this petition, in this appeal. The same is therefore disposed of. However, it would be open for the respondents to argue the law points involved in it, involved in this matter in up to suitable proceedings, as and when it comes before the court.
So please.
Item number 7.
The number so and so is also displayed.
My lord, in this. My lord, in this writ appeal, notice was issued we took steps also for serving the private respondents. Now, there are about 330 private respondents in number. And as per the report, some respondents have been served. My lord,
So what about the other respondents?
my lord, we may have to await,
They already awaited,
already awaited, that's right, my lord, on last two or three orders. There are 330 total.
how many of the respondents are served?
My lord, I think about 50 in number,
Only 50.
only
Out
about
of 336.
330, yes.
330. Paper publication.
My lord, on the stage of condonation of delay also, we had actually carried out paper publication, but no one came forward. But now after that, after we effected the service through,
Again, get a notice published, they will consider it.
my lord, can we wait once because we've already incurred that?
In fact,
Once.
the notices are already awaited.
I'm in my lord's hands. My lord says that.
9/11. No. Okay, notice should by this court to the respondents have not been served on each of the respondents. Would stop, let the matter be placed before the Lauzima court for passing necessary orders. List after the list once the Lauzima court makes an order.
Obliged.
Item number 8 and 9.
With please, your lordship, as per office note 1 to 24, lordship, the service is awaited in respect of private respondent number 2 and 3, lordship.
Yes. How many respondents are there?
Only in respect to item number 8, lordship, 2 respondent is there, lordship. 1 is already appeared, 2 and 3 notice.
The notices have already been served.
So far as my lord, writ appeal 467 is concerned, one of the respondent is here, my lord, who is a appellant in writ appeal number, my lord, 458.
Yes.
So
The service.
respondent number 3.
Respondent number 3.
Respondent number 3 is the appellant in writ appeal number 458.
Yes.
And so far as respondent number 2 is concerned, my lord, there was no direction against respondent number 2. She is merely a formal party, my lord. There was no direction by the honorable single judge against respondent number 2.
Otherwise, he is made a party in the repetition, lordship. So,
But there was no effective order against.
Respondent, you mean to say that there is no requirement of service of notice upon the respondent number 2 and 3?
Look, there was no direction by learned single judge
All
against
India
us.
Institute of Medical Sciences.
lordship.
This was a selection proceeding initiated by AIMS for the various posts of associate professor and assistant professor. And we challenged the selection process.
Fine.
The reason is that the selection committee conducted one interview and made 2 assessments for 2 different posts and gave 2 different marks. For the higher post of associate professor, I was given more marks by the same interview. And for the lower post of assistant professor, I was given lower marks, my lord. That is impossible, my lord. One interview held same time, same interview committee members. My lord, the candidates appeared. And out of that, my lord, 2 assessments were made. And on that count, the honorable single judge interfered with the selection process.
whatever it may be, if the selections are for the aims, then certainly the aim is the necessary party. It has to be.
Well, Ames is here. We have
My friend
preferred-
is appealing for aims.
Lordship, we have preferred the appeal, Lordship, item number 8.
The standing so this writ petition is
Uh,
on behalf of the
467 is by
In-
aids
candidates.
Lordship.
and 458 is by the affected person. my lord. So my humble prayer that, my lord, there is some urgency in the matter. If this matter can be heard
Is
at,
there any stay?
yes, my lord, there is a status quo order passed by this honorable court, my lord.
So now the,
There has been passed in item number 9.
Yes, my lord, 458. The interim order was passed in,
9, my lord.
yes, item number 9,
Yes, my lord. On 15/12.
which are the stay is there.
yes,
The status quo there, Lordship.
Well, as per office note dated my lord 1/2/2024, the steps on respondent number 6 is awaited, my lord.
Who is the respondent number 6?
One of the selected candidate.
she was the other person against whom, my lord, there was no direction by the honorable single judge, my lord.
Otherwise, Lordship, he has made a party in the writ petition by the petitioner, Lordship.
Well, there is an order on 15/12 that to take registered steps on respondent number 6. Accordingly, we have taken steps. Yes. There is an order.
Is not required to be heard.
And at that time, my lord, no objection was raised by the my lord, respondent number 1.
You agree with this that respondent number 6 is not required to be heard?
My lord, that's his submission, my lord. We had.
No, lordship will kindly have the,
That's why only you are the appellant. So you mean to say that respondent number, the presence of the respondent. number
Otherwise, my
6
lord,
is required?
otherwise, my lord, her appointment has not been interfered by the learned single. But since he was a party in the writ petition, we have made a party in the appeal.
Both sides agree that respondent number 3 in first item and 6, same person in the second item,
Lordship.
is not a necessary party in this appeal. We can strike off the name of the respondent.
That part, my lord, I cannot say, my lord, because ultimately, because there are two persons who are, my lord, selected by the same.
So the
selection body.
respondent number 6 is posted here only. Our respondent number
Respondent
3
number-
and 6.
Respondent number, Lordship, 6 and appellant number, item number 9, Lordship. Both are posted in
Same
the
person, but
Same person,
Same.
same person.
residing in Guwahati only.
in the
In
Ames
in the
campus.
Aims.
Ames campus.
Get the notices served upon by the state notices. are
my
registered.
friend, there.
She is there employing it. Why don't you serve notice on her?
Lordship, already we have taken step as per court's order, Lordship.
No, she is working under you.
Lordship,
Yes.
Lordship.
Yes,
Serve
yes,
notice.
he can do that.
Lordship, I can.
Okay, as per the office report, notice upon the respondent number 3 and the respondent number 3 in writ appeal number 467 and respondent number 9 in writ appeal number 458, 6. sorry. Respondent number 6 in writ appeal number 458.
Yes,
Respondent number 6 in writ appeal number 458 is not complete. Stop, it is noticed that the said respondent is the employee of All India Institute of Medical Sciences, Kamrup, Assam. In such circumstances, we direct the counsel for the appellant in writ appeal number 467, 2023 to get the notices served upon the respondent number 3 and 6 respectively through the director Ames Assam by the next date of hearing.
Lordship. Lordship, I have to take Dusty or Lordship directly we have served notice. Lordship.
The requisite hearing by receiving the notices Dusty.
Lordship, Lordship.
Stop requisites to be filed within a period of 1 week.
Lordship.
Notices are made returnable on 14th of March.
Lordship, Lordship, Lordship.
14th of March.
May pray for some early date, if not inconvenient. If possible, let's. Fine, man, fine.
We have
Well,
If the other appellant also.
Item 9 may be extended, man.
interim order passed in writ appeal number 458/2023 is extended till next date.
The appellant in 458, writ appeal number 458, he may also serve the copy through my, the appellant in
I
four
will serve, Lordship, I will serve.
You get it?
Item 10,
highly obliged.
May I please, your lordship? My lord, as per the office note, my lord, 6/1/24, my lord, the service for the respondents awaited, my lord. In this case, already we have taken twice steps. Now today, my lord, I am praying for bringing justice service, my lord, for
Irrigation, no?
Quite you.
Irrigation.
Quite you.
Registered post with AD within 1 week.
Yes, Lord.
That has not been served.
Paper.
लिखिए, notice issued to the respondent number 1 and 2 has not been served till date. Full stop. At the request of the learned counsel for the respondent number, for the appellant. For the applicant. Fresh notices be issued
May,
to the
may I, Lord?
respondent number 1 and 2.
Lordship, so far as 1 and 2 is concerned, Lordship, I have instruction to appear in this matter, though I have not filed Okalatama yet, Lord.
Let me, my lord. Then, my lord.
लिखिए. As per the office report, service of notices on the respondent number 1 and 2 is not complete. However, Mr. So and so put an appearance on behalf of the respondent number 1 and 2. Service is therefore complete. Mr. So and so prays for and granted time to complete his instructions. List all,
Lordship will take up this matter after 2 weeks, Lordship.
any date after 2 weeks. Inform the date.
Deeply obliged.
Obliged.
item 11,
There is a office note, my lord, in the contempt case, my lord. 15/2/2024. Notice has been served upon the sole respondent, my lord.
Not complete on sole respondent.
Yes, my lord, not complete. Respondent number on sole respondent, my lord.
Yes, so fresh
Yes, my lord, yes.
as per the office report. Service of notice upon the sole respondent is not complete. Let fresh notice be issued to the sole respondent, returnable. Requisite be filed within a period of 1 week. And be given the same.
Yes, my lord, this, that's,
And, simple, issue, requisite be filed within so and so, returnable on. 19th of March.
obliged.
Yes.
item 12,
May I please, your lordship?
Yes.
Your lordship, this application has been filed for condonation of delay, your lordship, 484 days. Your lordship, in filing the corrected appeal, your lordship.
Lordship, I am appearing for private respondent number 6, Lordship, on behalf of Ms. R. Devi. Lordship, we have filed the objection to their condonation delay, Lordship.
Condonation of delay.
Lordship,
How?
Lordship, on 17, we have filed, it has not come on record, Lordship.
Is your objection?
Lordship,
What is your objection?
Lordship,
In fact, they have preferred a review petition which came to be decided later on. Within few days of dismissal of the review petition, they have preferred this rate appeal. There is a case for delay condonation.
Lordship, some direction required from my senior.
So, when you have filed those objections.
Lordship, 17th, Lordship.
17th, Mangala, objection.
Put it on record.
Okay. The matter comes up for consideration of IA number so and so with a prayer to condone the delay of 484 days in preparing this appeal. briefing connected appeal. Full stop. It is submitted by the counsel for the petitioner, counsel for the applicant, that the Senate single judge has passed the order impugned on 26/9/2019, against which the applicants have preferred a review petition within limitation. However, the said review petition also came to be rejected while order dated 9/1/2023, and immediately thereafter on 7/2/2023, this IA along with the connected appeal is filed. Which stop. And then counsel for the appellant has submitted that the delay caused in filing the appeal is bona fide, and therefore the same is liable to be condoned. Stop. Per contra, and the counsel appealing for the respondent number 6 has opposed the respondent. Other respondents have not filed any response.
Others are official respondents.
So there is no response to this IA on behalf of the respondent number 1 to 5. However, the respondent number 6 has opposed the application seeking condonation of delay. Having heard the learned counsel for the parties, and after going through the contents of the IA, we are of the view that the delay in filing the connected appeal is sufficiently explained by the appellants, by the applicants. Hence, the application under section 5 of the Limitation Act is allowed. The delay of 484 days is condoned. List for admission after 3 weeks. List the appeal for admission. The appeal be registered on it. The registry is directed to register the appeal and list it for admission after 3 weeks.
Lordship, can it be 2 weeks, Lordship, because I am going to retire.
2 weeks.
I'll apply.
I instance this for the.
Record objection. Item 13.
Well, it's a repeating, there is 171 delay, but Lordship, you should notice we have taken drastic steps, and
Brother-in-law has received.
Similarly, brother-in-law has received.
Brother-in-law how will presume this?
But in presence of witness, another witness is there.
Witness may be witness, but
At his
he may or may not inform.
at his residence, we have given.
I don't know when it's another. Well, it's got fresh notice करवाई लो. Stop. As per the office report, the notice issued to the respondent. Who is the respondent?
Respondent number 1, opposite party number 1.
By his brother-in-law. Stop. Let fresh notice be issued to the respondent number 1 and be given custody to the counsel for the appellant for applicant for appellant.
Just to tell you that this is by state. Application is by state. Just you want dusty?
Lordship, we'll take dusty.
Custody the counsel for the appellant. Returnable on function.
Item 14.
May I please, Lordship? Well, in this case, my lord, service upon all the respondents are complete, my lord. And my learned friend appearing for the official respondents, but nobody is appearing for the private respondents.
521.
My lord. May I pray, my lord, matter may be fixed for admission hearing. This service has already been complete, my.
Okay, as per the office report, service of notices upon all the respondents is complete. Let this appeal be listed. Petition. Writ petition be listed for admission after 3 weeks.
My lord, may I pray, my lord, for a fixed date, my lord? Any date, my lord?
2 weeks.
My lord, 2 weeks. Oblige.
Item 15.
May I please, the interlegal application lordship for condonation of delay lordship. 94 days is delay to preparing the appeal lordship.
Lord, we don't have any objection and listed for.
Yes,
My lord, we don't have any objection as such.
you don't have?
Any objection, my lord.
Okay.
Can be listed for admission.
The matter comes upon the consideration of the IA number so and so. With the prayer to condone the delay of 94 days in petitioning the connected appeal. Of having heard the learned counsel of the parties and after going to the contents of the application, we deem it appropriate to condone the 94 delay, condone the 94 days delay in filing the appeal. Hence, the IA is allowed the delay in filing. The connected appeal is condoned. IA is disposed of. Registry is directed to register the appeal and to register the connected appeal and to place it for admission before this court after a week.
Item 16.
Lordship, I have obtained instruction, the executive proceeding is fixed on 22nd of February, Lordship, for hearing.
What happened in those proceedings?
It is pending, Lordship, fixed on 22nd of February, Lord.
Fixed on 22nd of February.
Lordship.
No final order has been passed till date.
Lordship.
Final order has not been passed.
Not been passed. Not been passed.
Not been passed, my.
As per my instruction, on number of occasions, heavy work speaks, but nobody appeared. It was done for
On behalf of them.
Lordship.
Lordships, as per my instruction, Lordships, we have given the reply, my lord. Thereafter, Lordships, the proceedings did not actually take place, my lord.
Why? For what reason?
Lordships, we visited the office, my lord. But Lordships, the hearing did not take place, Lordships. Therefore, Lordships, we did not, it is for the authority, Lordships, to conduct, to actually, my lord, pass orders on the proposed notice, my lord. And Lordships will, my lord, most respectfully see that Lordships, this is a case where Lordships, there is an illegal seizure, my lord. In a case where Lordships, the seizure is illegal, Lordships, the proper officer, Lordships, does not have, my lord, in my most respectful submission, Lordships, does not have the jurisdiction to, when the proper officer, my lord, does not have the jurisdiction to seize the goods, my lord, then your Lordships can interfere, Lordship.
Ultimately, in those search proceedings, whatever the goods of this objectionable nature were found there.
Lordships will maybe pleased to see, my lord, that Section 110 of the Customs Act, my lord, Section 108, my lord, it very clearly indicates, my lord, when there are reasons to believe, it is only then the proper officer can seize the goods, my lord. Now, Lordships will see from the records, Lordships will see from their reply and from the records that, my lord, this is a case, my lord, in my most respectful submission, that there were no reasons to believe, my lord, for the proper officer to seize the goods. And Lordships, no reasons have been passed either in the order or in the documents that have been annexed in the affidavit in opposition, my lord. No reasons have been given by the proper officer justifying the seizure, my lord. When Lordships, no reasons are given by the proper officer justifying the seizure, Lordships, the seizure becomes bad, my lord. Lordships, may be pleased to turn to page, my lord, 90. And Lordships, before Lordships sees the seizure order, my lord, just one small submission, my lord.
Show the seizure.
Seizure order is page 97, my lord. Reason of seizure, 5 Lordships will see reason of seizure, illegal import, my lord.
Yes.
This cannot be the reason, my lord.
Why?
Because Lordships, when an import is illegal, if they are saying that smuggled goods, illegal import, it is the final belief, my lord. It is not the reason.
Final?
It is the final belief, my lord. It is the final belief. If they are saying that the goods are smuggled goods, this is a conclusion which they are arriving at, my lord. This is not the reason, my lord.
Illegal import, now you have to demonstrate whether it's
Lordships,
legally imported or
Lordships will see, my lord, most respectfully submitting, my lord, Lordships will be pleased to turn to page 110, Lordships, section 110 of the Customs Act, my lord. Once, Lordships.
Yes. Seizure of goods, documents and things.
Lordships.
Yes, read.
Seizure of goods, documents and things. If the proper officer has reason to believe that any goods are liable to confiscation under this act, he may seize such goods. Now, Lordships, this reason to believe, my lord, is the condition precedent, my lord, for the proper officer to exercise jurisdiction. If these reasons are not there, the proper officer, Lordship.
So this notice is for confiscation.
The notice no, lordships, they are saying that, seizure has already been done, my lord. This notice is for, my lord, they'll be levying us penalty, my lord, on the basis of this notice, my lord.
Where is that
Please.
Where is that notice?
Yeah, maybe, I know.
Additional FATF, they file page 209.
209, my lord. Lordships will see page number 279, my lord. Two seven nine, my lord. May I read, my lord, relevant portion?
Yeah. What is this officer concern has recorded the reason to believe?
No, lordships. Lordships may be pleased to turn to, my lord, page, lordships, this is the, lordships, this is the, in the, reason to believe is illegal import. This is only they are saying, my lord.
Just show us, where is that?
Page 97, my lord.
97.
Lordships,
No, 97 is okay,
lordships.
but as you have argued that he has not recorded or has no reason to believe,
Yes, lordship.
from where we get this?
Uh,
Before doing this seizure,
Lordships,
whether is he initiated any proceedings or what?
Lordships, the proper officer.
Yes,
Lordships, the proper officer directly sees the goods, my lord. Lordships,
now in the,
no such reasons have been passed.
okay, now in this order,
Lordships,
this page 209 or 2010,
Lordships,
210, sorry.
Lordships,
Specific information was received to the effect that the dried areca nuts are foreign origin, illegally smuggled into Indian territory, has been loaded at the railway wagon, so and so, so and so. This is not the sufficient reason to believe. If,
My lord.
if the authority concerned is in
Lordship.
receipt of any information
Lordships,
that some illegally this goods smuggled into the Indian territory has been loaded at the railway wagon, and they immediately conducted a search and
Lord.
found some objectionable material.
Lordship,
What's wrong in that?
my lord, Lordships will see when the seizure is made, my lord.
Yes,
It is then, Lordships, that the reasons have to be given in the seizure order. It is
Yes,
not,
but-
Lordships, through an SOCO's notice, they can justify that, see, there are reasons for seizing the goods. And this is the mandate of the law, Lordship.
Your Honor, if suppose they seize the goods on a railway station, from where they supply those reasons? And
My
then
lord, this is an exercise which they have to do before seizing the goods.
before seizing the goods, suppose they are in receipt of information that the train is leaving the station within 10 minutes. and
Lordships.
Some goods are there. Is there any time for them to record the reasons, and then first of all they record the reasons,
My lord,
and then only they
my lord will-
go for seizure?
Lordships,
At that time, the goods will go from there.
my lord, may be pleased to turn to my lord, page 90. There is an instruction of the department, my lord, which is mandatory in nature, my lord.
Read.
Lordship. 96, my lord, may be pleased to turn to page 96.
The proceeding is the application of the fact, release this. Then file photo reply and along with the application. This is a thesis.
My lord,
The Shoko's notice is a
Lordships,
thesis paper.
Lordship,
And you are saying there is no reason.
Lord-
70 pages he has written.
Lordship, 70 pages, my lord, in my most respectful submission, my lord. It is, my lord, Lordships will kindly appreciate, my lord. It is when the goods are seized, Lordships. It is then the proper officer has to give reasons. It is not that, my lord, they seize the goods and they give reasons, my lord.
What has happened to your application for release of the seized goods?
My lord, that was disposed of, my lord. And
Rejected.
no, it was rejected, my lord. They did not.
Prefer any appeal against that?
No, my lord, since seizure is under challenge, Lordships, we are challenging the seizure, my lord.
May I intervene, Lord? But can you come to page 110, Lord? You know, next page 111, Lord. Next page 111, Lord. The information report, Lord.
Lordship,
111.
Lordships has seen,
Just a minute.
Lordship.
Yes.
You know, the information recorded that one firm name SR Enterprise in collaboration with Sri so book wagon number so for any of the transportation of ended grapes of Arecanut to Kanpur, Uttar Pradesh from wherever is registration, and the same train is leaving wherever is station so. Clause number 7, proposed action. Stream of so. Then on the next page, with the
Lordship, in
inscription.
these two documents, my lord.
Mr. Garodia,
Lordship,
there is,
Lordship.
there is no production of Arcanats in Mizoram.
Yes, there is no production. Lord.
So
Lordship,
where did you get it in Mizoram, 800 bags?
my lord, we have purchased it from Lordships. I am a resident of Hailakandi, my lord. During this time, what has happened is, Lordships, my lord, I used to supply it from Lordships. I used to book the wagons from Silchar, my lord. It is only from Silchar I used to transport it to Kanpur. It is during the lockdown period, my lord, I had to go to Bairabi, my lord.
Page 120 is the report of the laboratory log. Page 120.
This is the order, this 110,
Lordship.
this he has passed along with the seizure of the goods.
No, this is the information recorded by the proper official, Lordship.
Fine.
And he have considered it in. Thereafter, Lordship, page 13. Is the page 111, Lordship.
111.
Lordship.
Yes,
It is the information report.
yes,
What action we have taken, that is the reducing, I think.
fine.
Then Lordship, page 112, Lordship, please to see is a description of the bigs, which is in my Myanmar language.
Description of the goods,
Yes, sir.
112.
112, 113, 114, and 115.
Yes,
Then 118 is a seizure, form of seizure report. Okay.
yes,
And Lordship, next page, please to see the reason for seizure. Illegal import, violation of section 713 and 11 of the Custom Act.
commission of, no, 11120,
So 118 is the seizure report. Lordship.
118.
Lordship.
Yes,
Column 2 is the date and time of seizure.
yes,
Detection on 28 to 20 and seize on 29/8/2020.
yes,
Then Lordship, next page, the value is mentioned. Then next page, Lordship, region for seizure.
illegal importation, violation of Rule 71 Customs Act.
Then Lordship, next page 120 is the report of laboratory, Lordship.
Report of
Laboratory, current trend, report of laboratory, Lordship. Paragraph 2. However, HR plant quarantine regulation import in India 2003, Petalna Sancho can be imported into India through notified points of entries on the basis of sanitary certificate issued by the exporting country. Therefore, in compliance of EQ order number so the consignment illegal import into India without valid sanitary certificate should be destructed and not fit for sale in India.
This is after around a month.
Yes, sir. Because samples were drawn and you were sent to the laboratory for testing. The reason recorded by the learned single digit page 136, paragraph 29 was what? रिप्लेसमेंट नहीं किया रिप्लेसमेंट नहीं किया कर दी कहाँ कब किया कर दी कहाँ कौन तो फिर मेरे पास कर दिया ओके रिप्लाई किया
Yes.
Lordship, may we please to turn to page 96, my lord.
96.
My lord.
Yes.
Paragraph 2, Lordship. May I read, my lord? It has been brought to the notice of the board that in several cases, goods are being held up seized by the field formation only under Panchnama and separate orders for seizure of goods are not being passed. The Honorable High Court in a recent order has held that a Panchnama is a statement by Panchas and cannot be taken to be an order passed by proper officer under section 110 of the Customs Act. Though section 110 of the Act does not specify passing an order for seizure of goods, it says that where it is not practicable to seize any such goods, the proper officer may serve on the owner of the goods an order that he shall not remove, part with, or otherwise deal with the goods except with the previous permission of such officer. In view of the above, my lord, next page. In all future cases, the following may be adhered to. Whenever any goods are being seized, in addition to the Panchnama, the proper officer must also pass an appropriate order clearly mentioning the reasons to believe that the goods are liable for confiscation, my lord. Now, lordships will see that there is a mandate of section through this circular, my lord. It's the mandate of the circular that proper reasons have to be given when goods are being seized, my lord.
What reason do you expect?
Lordship.
They are saying that there is a reason to believe that the goods are smuggled from the border.
Lordship.
Reasons else. That the name of the smuggler or something, and that has to be recorded or what?
My lord, most respectfully submitting lordships. What has fallen from your lordships is the final belief and what the respondents have in the various documents that have been.
I don't believe you mean to say that at the time, he must record the reasons that these goods are smuggled goods without giving you any opportunity of hearing.
Lordships, this is the mandate of
Now,
law.
he has issued a show cause notice. You show your case that no, these are not the smuggled goods and I have purchased this legally. Then only you can pass an order under section 110A.
My lord, this is not the most respectfully submitting lordships. This is not the mandate of section 110 of the Customs Act. Section 110 of the Customs Act very clearly says, my lord, that for the officer to exercise action under section 110 of the Customs Act, there has to be reasons to believe. These reasons to believe, my lord, in my most respectful submission, are conditioned precedent for the proper officer to exercise his jurisdiction. Now, lordships, in a case where there are no reasons to believe, he cannot seize the goods. Since he has seized the goods, it is for the proper officer to show that there were reasons for seizing the goods. Now, lordships, may please to turn to 112, my lord, section 112 of the Customs Act.
Yes,
Section 111, my lord.
yes.
Confiscation of improperly imported goods. The following goods bought from a place outside India shall be liable to confiscation. Any goods imported by sea or air which are unloaded or attempted to be unloaded at any place other than a customs port or customs airport appointed under clause A of section 7 for the unloading of such goods. Any goods imported by land or inland water through any route other than a route specified in a notification issued under clause C of section 7 for the import of such goods. Any dutiable or prohibited goods brought into any bay, gulf, creek, or tidal river.
These are the instances.
Lordships.
Yes.
These are the instances, my lord. It is only when such an instance is present. It is only when the proper officer can show that, see, this is an instance on the basis of which we are confiscating the goods. It is only then, lordships, he can exercise power under section 110 of the Customs Act. If these instances, my lord, if the proper.
B is clear.
Lordships.
This B, any goods imported by land or inland.
Lordships.
Water through any route other than a route specified in notification issued under C of the Import of the Goods Act. And they have mentioned it section 7.
They have mentioned the provision, my lord,
Yes.
but they have not said that this is how the goods have been bought. It is. No, this is
So you mean to say that the authorities
lordships
are
will see.
required to know in advance that which route the smugglers are going to take for smuggling the goods. Then what type of smugglers those are?
My lord, lordships will see that unless.
How can you expect them route? They are aware about the route itself. Then when was the occasion for them to seize the goods? They could have stopped there at the border itself.
Yes, my lord. They cannot come and say these goods are smuggled goods. We are seizing it. They have to, lordships, ultimately they are exercising confiscatory jurisdiction. And lordships, to exercise confiscatory jurisdiction, my lord, in my most respectful submission.
What were the Arkanats doing in Mizoram? How did it reach there, according
lord.
to you?
Lordships, we have.
But it's not produced in Mizoram.
Lordships.
Why were the Arkanats booked in Mizoram for UP? Where did it originate? Can you please tell us?
Lordships, most respectfully submitting, my lord. Lordships, may please to turn to page 77, my lord.
Please tell us.
Lordships.
Why did you take the goods to Mizoram to book it for Uttar Pradesh?
Lordships.
When there is no production of this item in Mizoram?
Lordships, we have purchased it, my lord. The petitioner is a resident of Hailakandi, my lord. He has
Purchased it from where?
purchase it locally, my lord. Yes.
Hailakandi.
Hailakandi, my lord.
Then you take it to Mizoram and from there you book it for,
Yes, my lord, because
you tell it to them.
the reason being this, my lord, that this was a corona time, my lord. Earlier also, I have sent goods from Silchar to, my lord, to Kanpur. But during this time, my lord, I could not book a wagon from Silchar to Kanpur. This is the reason, lordships, I took it to Mizoram. And my lord, it is their case, lordships, that it has originated the trucks which brought the goods to Mizoram. These trucks have come from Hailakandi, lordships. It is their case, my lord. It's not our case, my lord. It is they who are respondents themselves are saying this, my lord.
Yes.
Lordships, Lordships has read, my lord, that instruction of the customs, my lord.
Page 96.
India map पता सुनिए just.
Page 96.
Page 96, my lord. Now, lordships, may please to turn to, my lord, 151A of the Customs Act.
151A of the,
Customs Act, my lord.
okay. Instructions to officers of the customs.
Lordships. May I read, my lord? Yeah. Yeah, perfect.
The instructions are having a binding force.
Lordship, the instructions are having a binding force, my lord. Now, lordships, we will please to turn to, my lord. I will be, lordships, citing two judgments, my lord. Lordships, 2004, I have given the book list, my lord. 2004, 2 SCR 511.
SCR
SCR 511.
51.
1.
You supply us the copy.
Lordship. Well, I have given the book list, my lord. This copy
I think so that book is not available with
my lord.
us. Supply the copy.
Lordship. The other one is 1996 10 SCC 387. It is good.
Then SCC
387, my lord.
387.
My lord.
Yes.
Paragraph 15, my lord. Case 392, my lord.
Just a minute.
Lordship. Lordship. May I read, Lordship, paragraph 15, madam?
Which judgment?
Lordship. 1996 10 SPC.
Yes. Paragraph?
Paragraph 15, my lord, page 392.
Yes.
There can be no doubt whatsoever in the circumstances that the earlier and later circulars were issued by the board under the provisions of section 37B, and the fact that they do not so recite does not mean that they do not bind central excise officers or become advisory in character. There can be no doubt whatsoever that after 21/11/1994, excise duty could be levied upon micronutrients only under the provisions of heading 31.05 as other fertilizers. If the latter circular is contrary to the terms of the statute, it must be withdrawn. While the latter circular remains in operation, the revenue is bound by it and cannot be allowed to plead that it is not valid. We reject the submission to the contrary made by the learned counsel for the revenue. And in the affidavit by M.K. Gupta, working as director in the Department of Revenue, Ministry of Finance, one should have thought that an officer of the Ministry of Finance would have greater respect for circulars such as these issued by the board, which also operate under the aegis of the Ministry of Finance. For if it is the board which is by statute entrusted with the task of classifying excisable goods uniformly, the whole objective of such circulars is to adopt a uniform practice and to inform the trade as to how a particular product will be treated for the purpose of excise duty. It does not lie in the mouth of the revenue to repudiate a circular issued by the board on the basis that it is inconsistent with the statutory provisions. Consistency and discipline are of far greater importance.
So it is
than
the stand of the revenue that we are not going to comply with this circular or what the
Lordship,
instructions.
uh,
It is
most-
the case of the revenue.
most respectfully submitting, my lord, that lordships, when there is this instruction which lordships has just read,
They are also
that-
agree to this proposition.
yes, my lord, that now this instruction has to be complied with, my lord.
That's another thing, but for
At
this judgment, you mean to say that it is binding, the Supreme Court has said in the reply or the revenue has said that, no, we are not going to comply with this, these instructions.
My
It is
lord.
the case of the revenue.
My lord, as per the instruction which your lordships has read,
It is the case of the revenue that these instructions, whatever you are referring at page 96, are not binding upon them.
no, my lord, they are binding and they have not been followed. This is my case, my lord.
That is what another thing. So this judgment is in relation to that where the revenue has come up with the case that this is not binding.
Not binding.
And the Supreme Court has said.
Said that is binding. It is binding, my lord. Similarly, lordships, in this case also, that instruction which your lordships were pleased to
They are,
read it, my
they
lord.
are not on the stand of the revenue is not this, that this is not binding. They are saying it is binding, and as per so far as what we have gathered, they are saying that we have followed those instructions. This is what in your case is that they have not followed the instructions.
Yes, lordships, there are no reasons and they have not followed the instruction, my lord. Now, lordships, there is one another judgment, my lord. That SCR judgment. Asset. Commissioner of Customs.
Yes.
Lordship, may please to turn to, my lord, paragraph 12, my lord.
Paragraph
12, my lord.
12.
May I read, my lord?
Yes, read.
Lordship. Although a circular is not binding on a court or an SEC, it is not open to the revenue to raise a contention that is contrary to a binding circular by the board. When a circular remains in operation, the revenue is bound by it and cannot be allowed to plead that it is not valid, nor that it is contrary to the terms of the statute.
Mr. Gonsalve, have already pointed out,
Lordship.
it is not the case of the revenue. Why these cases are relevant for that purpose?
Lordship,
Your simple case is that they have not followed the instructions, and their case is that we have followed the instructions. Now we have to decide whether the instructions have been followed or not.
Lordships has to see, my lord, that there were actually reasons to believe or not, my lord.
That's right.
Lord. Now, Lordship, in order to further substantiate my contention, my lord, Lordships, I'll be relying on Lordships. 1961 to SCR. Nineteen 61 to SCR to Kerala. Oh. Oh, Calcutta High Court of Calcutta Discount. It was no, Supreme Court, Calcutta Discount Income Tax Officer. दादा अपनी कोणतो AR को ओलाई दिसन.
Yes.
Lordship. My lord, I'm citing one judgment, my lord, 1961 to SCR 241, my lord, with my.
No, Mr. Garodia, what is the point for which you are relying upon? Please tell us that.
Lordships.
Then to believe.
Lordships, this is a judgment, my lord. I'm citing to substantiate this, my lord. When the proper officer is exercising his powers, reason to believe is the condition precedent to exercise such powers, my lord. Paragraph 26 of the judgment, my lord.
But in Indru Ramachandran's case, the Supreme Court has said,
Lordship.
court cannot sit in appeal over the satisfaction of the officer. Is that not correct?
Lordship, that is, my lord. Lordships will see, my lord. This is very, it has been very, Lordships very clearly explained, my lord, in my most respectful submission. The court, Lordships, this apex court, Lordships, very categorically states, my lord, that if there are no reasons to believe, then, my lord, the powers exercised by the proper officer is beyond jurisdiction and the courts can interfere, my lord. Very clearly stated, my lord.
Yes.
My lord, the copy that has been given to Lordships, my lord, that is AIR, my lord. I have Lordships SCR copy with me.
Okay. We should know.
My lord,
We'll find out.
Mr. Sastry next pointed out, my lord, I am relying on this paragraph, my lord.
In the mid of the, or in the concluding part of the judgment.
Lordships, yes, Lordships. Before the judgment given by Lordships Justice J.C. Shah, my lord.
Yes,
This is the Constitution Bench judgment, my lord.
yeah.
My lord, may I
Mr.
read?
Shastri next pointed out.
Next pointed out that the stage when the income tax officer issued the notices, he was not acting judicially or quasi judicially, and so a writ of certiorari or prohibition cannot issue. It is well settled, however, that though the writ of prohibition or certiorari will not issue against an executive authority, the high courts have the power to issue in a fit case an order prohibiting an executive authority from acting without jurisdiction. Where such an action of an executive authority acting without jurisdiction subjects or is likely to subject a person to lengthy proceedings and unnecessary harassments, the high courts, it is well settled, will issue appropriate orders or directions to prevent such consequences. Mr. Sastry mentioned more than once the fact that the company would have sufficient opportunity to raise this question, whether the income tax officer had reason to believe that under-assessment had resulted from non-disclosure of material facts before the income tax officer himself in assessment proceedings, and if unsuccessful, there before the appellate officer or the appellate tribunal or in the High Court under Section 66 of the Income Tax Act. The existence of such alternative remedy is not, however, always a sufficient reason for refusing a party quick relief by a writ or order prohibiting an authority acting without jurisdiction from continuing such action. In the present case, the company contends that the conditions precedent for the assumption of jurisdiction under Section 34 were not satisfied and come to the court at the earliest opportunity. There is nothing in its conduct which would justify the refusal of proper relief under Article 226. When the Constitution confers on the High Court the power to give relief, it becomes the duty of the courts to give such relief in fit cases, and the courts will be failing to perform their duty if the relief is refused without adequate reasons. In the present case, we do not find no such reason for which relief should be refused. Now, Lordships, okay. Okay. 1998.
Yes.
Badly.
Whirlpool Corporation.
Lordship,
Whirlpool Corporation.
Whirlpool Corporation, my lord. To substantiate this, my lord, that when
Alternate
the
remedy is not a bar.
alternative remedy is not a part. Now, Lordships, most respectfully submitting Lordships, I'll try my Lordships, I'll try to highlight Lordships. What is the reason to believe, my lord, through some judgments, my lord. May Lordships, this is 2004 11 SCC 576. Yes, Krishna.
Yes.
My lord, may we please to turn to page number 583, my lord.
Yes.
Paragraph 9, my lord. May I read, my lord? Under IPC, guilt in respect of almost all the offences is fastened either on the ground of intention or knowledge or reason to believe. We are now concerned with the expression knowledge and reason to believe. Knowledge is an awareness on the part of the person concerned, indicating his state of mind. Reason to believe is another facet of the state of mind. Reason to believe is not the same thing as suspicion or doubt, and mere seeing also cannot be equated to believing manner. Reason to believe is a higher level of state of mind. Likewise, knowledge will be slightly on a higher plane than reason to believe. A person can be supposed to know where there is a direct appeal to his senses, and a person is presumed to have a reason to believe if he has sufficient cause to believe the same. Section 26 of IPC explains the meaning of the words reason to believe thus.
Yes.
My lord. Reason to believe. A person is said to have reasons to believe a thing if he has sufficient cause to believe that thing, but not otherwise. In substance, next paragraph, my lord, paragraph 10. In substance, what it means is that a person must have a reason to believe if the circumstances are such that a reasonable man would, by probable reasoning, conclude or infer regarding the nature of the thing concerned. Such circumstances need not necessarily be capable of absolute conviction or inference, but it is sufficient if the circumstances are such as creating a cause to believe by a chain of probable reasoning leading to the conclusion or inference about the nature of the thing. These two requirements, that is knowledge and reason to believe, have to be deduced from various circumstances in the case.
Yes.
Now, lordships, what I'm trying to highlight is, lordships, that mere seeing is not believing, my lord. And on the basis of suspicion, on the basis of doubt, it cannot be said that there are reasons to believe. There have to be, my lord, something which is, lordships, in my most respectful submission, which can be deduced by a chain of probable reasoning leading to the conclusion or inference about the nature of the thing, my lord.
So, Mr. Garodia,
Lordship.
you argue your case,
Lordship.
but please also consider if
Lordship.
your argument is accepted,
Lordship.
then it is fine.
Lordship.
If the court holds that there were reasons to believe, that is the end of the road for your client. All the way. Please be careful about it. Because your only ground is there was no reason to believe.
Lordship.
We said it, we are not going to go into sufficiency of reason.
Lordship.
If the answer to your query is in the negative, that there were reasons to believe, that's the end of the road for your client.
Lordship.
Unless you get relief from the apex court. Are you conscious of this?
Lordships, we are very much conscious of this, my lord.
So
Now,
you are not availing the statutory remedy.
now, lordships, may we please to appreciate, lordships, our predicament, my lordships. These aspects, my lord, whether there was reason to believe at the time of doing seizure or not, it has been decided by the learned single judge, my lord. Now, if your lordships interferes with the said judgment, my lord, it's going to benefit us in the proceedings, my lord. But if lordship does not interfere, lordship.
Interfere in the benefit you in the proceedings. Suppose if we allow this petition,
Lordship.
make an order for allowance of the writ petition, then which proceedings then will remain? No. There's no proceedings then. all the proceedings will be deemed to be concluded by the, with the allowance of, allowing the writ petition.
Lordship.
Benefit, yeah, all either you get the whole benefit or will not get benefit. That's the only.
Lordship. No, Lordships, maybe pleased to see one thing, my lord, that learned single judge has said, my lord, in paragraph 35, my lord, page 138 of my writ appeal, my lord.
Yes.
After taking into consideration the law laid down in the subject of interference at the stage of issuance of so cause notice, this court is of the view that in most of the cases, such interference has been deprecated, whereby inquiries have been installed and investigation retarded, which was initiated to find the actual fact. Therefore, only when the court is of firm view that there is bona fide in the act of so cause notice or the same is bad for want of jurisdiction, it should not be entertained in a routine manner. In view of the aforesaid discussion, this court is of the view that the present case is not a fit case for invoking extraordinary powers of the under Article 226 of the Constitution of India. Accordingly, the writ petition stands dismissed. It is, however, made clear that the dismissal is merely on a technical ground and the observations made on the merits are tentative in nature, which would not cause any prejudice to either of the party. Which, Lordship, therefore, my lord, as per my lord, my understanding, it says that, my lord, that in the so cause notice proceedings, my lord, these findings will be of a tentative nature, my lord, and even in the so cause notice proceedings, my lord, we can raise all the grounds that are available to us.
Why not? But the thing is, once you are arguing with all this, with all your strength,
Lordship,
then certainly, if we doesn't agree with the order of the learned singles, that's another thing. But if we agree with the learned singles, then we have to record some reasons. And in that case, maybe a finding can be given that the officer has the sufficient reasons to believe. Maybe, or may not.
Lordship. Now, Lordships, what I am trying to impress upon my Lordships is that there is no reason for them
Therefore,
to.
whatever the proceedings they have conducted, the whole proceedings are V-shaped.
V-shaped, yeah. My lord, Lordships, this is my instruction, Lordships, to.
Certainly, then it's okay, we'll go on.
Lordships, if I may most respectfully say, Lordships will kindly be pleased to admit this matter, and Lordships may be pleased to hear it
But
finally,
we
my
have
lord.
heard for almost an hour.
Almost an hour, my
Question
lord.
of, admitting the matter again. We'll go by the, we'll pass an order, whatever the appropriate order.
Lordships,
Try
if
to admit.
Lordships has heard it at length, my lord. But Lordships may just pray, my lord, that let your Lordships, my lord, admit this matter, Lordships, and in the meantime, they will also come up with Lordships, the records.
Worth of admission, we'll pass that order.
Lordships.
If it is worth the matter, worth admission, we'll pass an order for admit also, but let us see. So this is what your argument is, that there was no reason to believe, and therefore the authority concerned has no jurisdiction to proceed further and they seize the goods.
Lordship.
So the seizure proceedings are V-shaped.
Lordship.
Yes.
Lordships, I have not, Lordships, I have few judgments, my lord, with which I would like.
Judgments, repetition, when the constitution bench, you have shown the constitution and what remains in the other judgment.
Lordships, there are, my lord, may be pleased to see few judgments, my lord, which would
Okay,
say.
you do one thing, you give the list, we'll go through all the judgments and we'll consider. So on one point, one judgment is sufficient.
Lordships.
Then why to burden this court or burden yourself by again citing the judgments on the very same point?
My lord,
You just give us the list, we'll certainly go through those judgments.
lordship. I've already given the list, my lord.
Yeah, that,
Those judgments, my lord, Lord, they explain the different facets of reason to believe, my lord. One such facet has been seen by your lordships, but there are certain other facets also, my lord, which I would like to highlight, my lord.
Specifically, your main ground is this, that since there was no reason to believe
Lordships,
with the officer concerned, and therefore the whole seizure proceedings are initiated. This is what the main
Lordship.
ground.
lordship,
And consider that, and in light of the judgments which you are referring, we will certainly consider those judgments.
Lordship.
Why are we apprehending that we are not going
No,
to
no, my lord,
consider those
lordships will
judgments then?
certainly, my lord. There is just, my lord, in order to highlight lordships that the proper officer needs to have objective considerations on the basis of which these reason to believe
Are based.
are based, my lord. In order to highlight this aspect, my lord, can I cite one judgment, my lord?
Okay, sure.
2015-11. 2015-11.
2015-11,
11 SEC, my lord, 6 to 8.
6 to 8, read.
Lordship. May I read, my lord?
Yes.
Statutes often use expressions such as deems it necessary, reason to believe, etc.
Which para you are referring to?
Paragraph 15, madam.
1-5.
1-5, madam.
Yes.
Statutes often use expressions such as deems it necessary, reason to believe, etc. Suffice is to say that these expressions have been held not to mean the subjective satisfaction of the officer concerned. Such power given to the officer concerned is not an arbitrary power and has to be exercised in accordance with the restraints imposed by law. That this is a well-settled position of law is clear from the following judgment. My lord, learned single judge lordships, in my most respectful submission, lordships, has held that it is on the basis of subjective satisfaction that such an power can be exercised. This judgment very clearly indicates, my lord, it is only on the basis of objective considerations that such power can be exercised.
Yes.
My lord. Lordships, one another judgment is 2008 13 SCC 305, my lord. Union of India.
305. Yes.
Paragraph 32, my lord. Page 317.
32.
32, my lord.
Yes.
In Gurbakh Singh, this court also held that before power under subsection 1 of section 38 is exercised, the court must be satisfied that the application invoking the provisions of anticipatory bail has reason to believe that he is likely to be arrested for a non-cognizable offense. My lord, next paragraph, lordships, may be pleased to read it from the middle, my lord. The grounds.
The ground on which the belief.
Yes, lordships. The grounds on which the belief of the applicant is based that he must be arrested for non-bailable offense, must be capable of being examined by the court objectively, because it is then alone the court can determine whether the applicant has reason to believe that he may be so arrested. Now, Lordships, may please to turn to paragraph 36, my lord.
Yes.
Paragraph 36, my lord. From the above discussion, it is amply clear that the power to arrest a person by a customs officer is statutory in character and cannot be interfered with. Such powers of arrest can be exercised only in those cases where the customs officer has reason to believe that a person has been guilty of an offense punishable under so and so. Thus, the power must be exercised on objective facts of commission of an offense enumerated, and the customs officer has reason to believe that a person sought to be arrested has been guilty of commission of such an offense. The power to arrest thus is circumscribed by objective considerations and cannot be exercised on whims, caprice, or fancy of the officer.
Yes.
My lord. 1972, CSCC 234.
The reason to believe he had.
Lordship.
In the latest judgment you have shown,
Lordship.
based on that, the 1972 judgment, all the judgments are here. We'll consider that, sir.
Lordship.
But it's the question of आपको हमको वो पढ़ाना ही है तो बात अलग है वो पढ़ लेंगे अब.
नहीं, sir.
We'll do that homework in.
My lord, there are two judgments, my lord, of the Allahabad High Court, which in similar facts and circumstances, Lordship, these two judgments, my lord, may be pleased to rely on.
The reason to believe में जितना मिला
Same, my lord, in these cases also, my lord, what has happened is, Lordships, that Arakan nuts were seized, Lordships, and the Honorable Court, Lordships, was pleased to set aside the seizure, my lord.
On what ground?
On the same ground, my lord, that there are no reasons to believe. No reason to believe.
Is that the only ground you're challenging the whole thing? No other ground?
No other ground.
Yes.
And my lord, what has fallen from your lordships, my lord,
This is the Patna judgment.
my lord, that this is the only ground, my lord. Most respectfully submitting lordships, this ground has two facets, my lord. The first facet is, lordships, that when the proper officer exercised his powers, there were no reasons to believe, my lord. And lordships, the other facet of this, my lord, most respectfully submitting lordships, is that as per the instruction which your lordships has just read, my lord, page 96 and 97, my lord. In terms of that instruction, before lordships, the goods were seized, it is the mandate of those of that instruction, lordships, that, my lord, the proper officer must have recorded the reasons and passed an order in that respect, which is.
But you are unable to tell us how the Arkanats reached Mizoram. You're not being able to give you see, the court must have a prima facie.
Lordships.
You're not being able to say anything.
No, lordships, I have very clearly highlighted, my lord, that these Areca nuts, lordships, were purchased in Hailakandi, my lord.
Where are the slips purchased?
Lordships. Lordships, may please to turn to page 77, my lord. This is the stock register lordships that I am maintaining, my lord.
Register,
Stock register lordships.
stock register, sir, what do you mean by the stock register?
To, my lord, when I
Purchase
purchased it,
from
I,
whom?
lordship, these name of the sellers are given there, my lord. At, in these lordships, in column number 3, my lord. Page 77, lordship.
What are the goods you have purchased?
These are areca nuts, my lord.
Where is that? Name?
I only deal in areca nuts, my
Hussain
lord.
Laskar, 377 kg purchase,
Lordship.
amount so and so. What was
Lordship.
the goods? It was a flour, areca nuts or what?
Lordships,
Or
these are,
some sweets or what?
lordships, may please to see, lordships, my, all these that have been the stock register lordships, all these goods, these are all areca nuts that I have purchased, my lord. And this is how lordships I am maintaining the stock register.
That is for the authority concerned to look into it, whether this is a proper maintenance of the register or not. So what you are referring to this Patna judgment, again, reason to believe.
My lord, if your lordships has just seen that, my lord, that page 77, may I highlight one thing, my lord, from that.
Yes,
Lordships, these purchases were made, my lord, from 1/5/2020, my lord, which is their lordships in the stock register lordships, from these various persons, my lord.
during Corona period.
Lordships during Corona period, my lord.
Yes.
Lordship. From the original copy of the stock register lordship is at page 83, my lord.
Okay. This is the type copy.
The lordships from
The
page
original
77.
copy is there, yes.
Lordship.
Yes.
Till page, my lord, 92, my lord.
92, yes. Yes.
Yes, lord.
Yes.
Lordships to reply to that query, lordships, which lordships has raised, my lord.
Which?
That, my lord, how come lordships the goods reached, my lord, Mizoram, my lord. In order to substantiate that, my lord, it is lordship, not our case, my lord, that the goods have, my lord.
It is their case.
It is there. They have.
They have smuggled, and your case is that you have purchased it from Anakandi, and thereafter now you are transporting it to the Uttar Pradesh
Lord.
by this train and nothing else. This is your case, and their case is that you have smuggled these nuts from Myanmar.
Lordship. No, my lord. In order further, my lord, how these goods arrived at Mizoram, it is also their case that the goods have reached Mizoram from Hailakandi, my lord. Not our case, my lord. It is their case. They are saying that the goods have reached from Hailakandi to Mizoram. In I will substantiate it, my lord. If this is the stand of the revenue, my lord, I'll substantiate this.
Ultimately, these are the facts in which we are not supposed to go into. We are simply will examine that whether there is a reason to believe the custom officer who has seized the goods was having sufficient reason to believe to
Yes.
proceed further or not.
Yes, lord.
This is what
That is the only thing, my lord.
why should we go into all this?
Yes,
From
Lord.
where you have purchased it or whatever it may be, that is a material for that.
Not material. My lord, that judgment which your lordships had just taken, my lord. Who can say? It was no, My lord, this judgment which was just handed over to my lords
Patna High Court.
at lordship Patna High Court, my lord. Page lordship paragraph 18 may be looked into, my lord.
18,
18. My lord.
yes.
May I read, my lord?
Read.
The consignor and the consignee are recorded and identified. The goods are not seized at any notified custom zone or area. Save and except for what is recorded in the seizure memo, there is no material available on record. The learned additional Solicitor General has tried to supplement the reasons for formation of reason to believe, which also are on mere suspicion through an affidavit of the authority. In the light of what is laid down by the Apex Court in Mohinder Singh Gill versus the Chief Election Commissioner, New Delhi and others, so and so, it would be impermissible for the authority to do so. When a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of an affidavit or otherwise. For a bad order, with the passage of time and supplementing the reasons would not become good, which is not how the authorities are required to function, more so in a case of confiscatory legislation. Now, Lordships, may please to turn to page 20, madam, paragraph 20, madam.
Yes.
While dealing with the same provision, Justice Rohington Fali Nariman in Tata Chemical so and so has explained the meaning of reason to believe by opining it to be not the subjective satisfaction of the officer concerned. For such power given to the officer concerned is not an arbitrary power and has to be exercised in accordance with the restraints imposed by law. And that such belief must be that of an honest and reasonable person based upon reasonable grounds. Further, if the authority would be acting without jurisdiction or there is no existence of any material or conditions leading to the belief, it would be open for the court to examine the same, though sufficiency of the reasons for the belief cannot be investigated. My lord, there is one, my lord, another judgment, my lord,
On this very point,
on lordships, similar aspect, lordships.
give us the copy of the judgment, we'll go through it.
Lordship.
Certainly, we'll go through it.
Lordships. My lord, before concluding, my lord,
Yes,
may I just,
still you are not concluded. Okay. Yes,
lordships, lordships, may be pleased to turn to the Caesar, lordships, the order of Caesar, my lord, which is at page 90, my lord, 93, my lord.
yes, you have already mentioned only illegal imports, the reason given.
'97, my lord.
97.
Yes, ma'am.
Okay, already,
Yes,
this
my lord.
reason to seizure illegal import.
Illegal
This
import.
is the only reason they are
The
given.
only reason they have given,
Yes,
my lord, and thereafter their affidavit, lordships.
affidavit,
Their affidavit in opposition, which was filed before the learned single judge.
counter, yes.
Yes, lordships.
They have supplied
At-
some more reasons.
At page 100, my lord,
100,
100, my lord.
yes. Yes,
Lordships will see, they have written, my lord.
yes.
The above seizure was done on the basis of specific information and based on circumstantial evidences such as Miarmi's inscription on a number of bags. They have highlighted, my lord, three such pictures, my lord, where there are Miarmi's inscription on the bags, my lord.
Yes.
Now, Lordships may be pleased to appreciate this, my lord, that solely on the basis of that Miarmi's inscription, goods cannot be seized, my lord. There were 800 bags. How many bags had Miarmi's inscription? It has not been highlighted by them, my lord. They have, my lord, and Lordships, these circumstantial evidence, this Miarmi's inscription, Lordships, this is at best it can be said that it's a circumstantial evidence, my lord. Now, Lordships has read 111 of the Customs Act, which says that these are the instances when the goods can be confiscated. Now, my lord, these circumstantial evidence, my lord, it can only corroborate the such instances. Until and unless those instances are shown by the proper officer, my lord, it cannot be, the goods cannot be seized, my lord. These are at best, Lordships, and Lordships may be pleased to see that first, Lordships, they have prepared the other document which they have highlighted, my lord, at page 110, my lord. The text of the information, my lord. They have said, my lord, at 110, my lord.
Yes.
May I read, my lord?
Yes.
Received an information from a casual informer that one firm named so-and-so, in collaboration with so-and-so, for transportation of 800 bags of smuggled areca nuts bound to Kanpur, Uttar Pradesh from Bairabi railway station, and said train is leaving Bairabi station at so-and-so time. Now, Lordships, in this text of information, they have already come to the conclusion that the goods are smuggled, my lord.
Information.
Received an information
Yes, that goods are smuggled.
that the goods are smuggled.
So they have simply noted down the information that we are in receipt of this information.
Yes, Lord.
That some smuggled goods are lying on the railway station, that's all.
Yes, Lord.
So information they are supposed to record.
Yes, Lordships. But what is that information, my
The
lord?
information that 800 bags of smuggled bound to Kanpur from so-and-so train, this is what the information
Yes,
they have
Lordship.
noted down.
Yes, Lordships.
Yes.
Now, my lord, what I'm trying to impress upon your Lordships is this, my lord, that when they are saying that the goods are smuggled, my lord,
Not they are not saying, they are simply saying we have
received an information that these are,
information that the smuggled goods are there.
yes, yes. Now, my lord, when it is there, when they receive this information that the goods are smuggled, my lord, to come to this conclusion, Lordships. Now, they have received some information on the basis of which they have come to the conclusion that these are smuggled goods, my lord.
To them to ascertain that information, they conducted a search or seizure, whatever it.
Yes, Lordship. This, there has to be, my lord, Lordships has read section 111, my lord, various instances. Now, to come to this conclusion that the goods are of smuggled nature, my lord, any one of those instances have to be there, and Lordship's reasons justifying that these are the instances, it is only on that, only upon Lordship's recording of reasons, then the seizure can be made, my lord.
You mean to say that whatever reason they have recorded or the information they have recorded is not sufficient to reason to believe
Yes, madam.
that these
Yes,
goods
Lord.
are.
There are no reasons to believe, madam. And the other page also, Lordships, 111 Lordships, there are no reasons, my lord.
That's right. 111, yes, no reasons, yes.
No reasons, my lord. So lordships, they have not supplied any reasons on the basis of which this seizure can be made.
Yes. That's all.
Lordship.
Yes.
Lordship has seen page 110. There is a sufficient reason to believe that these goods were foreign made goods and booked through railway. And Lordship, page 111, Lordship, column 1, commodity. 800 bags of Areca nuts of foreign origin. Then in page 111, Lordship, reason has been recorded. Then Lordship, next 4 pages from 112 to 116. The inscription.
Yes.
Myanmar language is there, Lordship. There's a reason to believe. Then Lordship, page 118 is the seizure report.
Yes.
It is also indicated in page 119, column 11, reason for seizure, illegal importation, violation of section 71C and 11 of Custom Act. Then Lordship, laboratory report is there. Lordship may come to page 132 of the London single judgment, paragraph 22.
That we'll read.
Lordship, in additional FATP in the notice, Lordship, may come to page 213. It was recorded that through whom they are going to ship the goods. He was examined. And Lordship, he stated that the main business of the
That
firm.
is, those proceedings are this after this
Yes.
seizure of the goods.
Yes, notice was issued, Lord. And this was our ground.
That's maybe that may be not of this.
And Lordship, it is also stated that from where they purchased the goods, it is not clear.
Okay, that's fine.
Much of it.
That is afterwards.
Not, yes, Lord.
Get it, take it, yes. What is that?
Much of
Sir, or is it?
Item 17.
Rate appeal. Lord, what happened? Under section 156(3), the special judge has asked the police to investigate into the matter under section, various IPC sections and the PCI. Now this short question arises here, my lord. Before investigation, whether sanction is required. The point is that, my lord, this matter was argued in the Supreme Court also, but there are divergent views. The
But
Supreme
we'll
Court,
refer to the larger bench.
larger bench. A larger bench has not come out as it. So my request to your lordship, should we wait till that time?
But this is referred since long.
My lord,
Since long it is,
2018 it was referred. Notice may be issued at this stage, my lord.
Notice, you are appearing on behalf of the,
My lord, before issuing notice, I just want to point out one thing.
yes,
The all annexure of the repetition is not annexed with this appeal memo. And my lord, affidavit in opposition we have filed before the single judge, that was also not annexed here. This is a defective one, lord.
here the defects, whatever it may be.
Fresh copies.
Whatever the defects they have said, they are not in receipt of documents as well as the counter affidavit.
Yes.
So, you supply them.
Yes, we,
Whatever the copy. indicate.
under an additional affidavit, we
Notice.
filed them.
Sir?
Under an additional affidavit, we filed them.
Whatever it may be, issue notice to the respondents. Mr. You are appearing for all the respondents,
My lord, I am appearing for 1 to 4,
1 to 4.
my lord.
And what about the other respondents?
I'm appearing for 6, Lord. Can you find help?
I will a private respondent.
5 is a private respondent.
Yes. Who has filed a complaint?
Okay. Issue notice, Mr. So and so put in appearance on behalf of the respondent number 1 to 4. Mr. So and so is put in appearance on behalf of the respondent number 6. Let notice be issued to the respondent number 5, returnable 6 weeks. Full stop. The consent for the appellant is directed to supply the complete record of the writ petition to the consent for the respondents within a period of 1 week.
Yes. I think, my lord, your lordship copy is also this is an incomplete copy.
Are
Yes, your lordship copy is also.
We'll do it, my lord.
they'll also submit to the court as well as to the
Yes, yes.
consent for the respondents 1 week.
Yes, I'm deeply obliged.
Next also same order.
Same is the same. 17 is the same.
Yes.
Item 20.
Yes.
Made, please, your lordship. My lord, the challenge, the petitioner is challenging the constitutional validity of, my lord, section 4 of section 16, my lord. In fact, similar matters are pending before this honorable court. And this honorable court was pleased to admit, my lord, the petition and matter are pending. But during the pendency of, my lord, writ petition, my lord, in respect of the judgment passed by Honorable Patna High Court, my lord, where the Honorable Patna High Court has upheld the validity, your lordship, matter went to Supreme Court, my lord, and Honorable Supreme Court on 3rd of January, your lordship, has been pleased to issue notice on interim prayer also, my lord. May I pray a similar order may kindly pass at this stage, my lord, your lordship.
Where matters have been admitted.
Before this honorable court, it is admitted.
Petition
number 176423.
You have the order sheet. Please
This is
supply.
the- So far in interim, my lord.
Then it may be same order as passed in this. Connect with. What are the number of its writ petition, WBC number 1764/2023.
Only your lordship may, so far as entry, my lord, notice may be issued so that.
Sir, interim, in fact, you may, the court has, for the present, the prayer of the interim. relief
True,
is-
my lord,
is-
because at
is-
that time, my lord, SLP was not there
is
before.
Not being considered for the present.
Present.
Anytime in future, if you are supposed to.
That's why, my lord, because Honorable Apex Court has been pleased to issue notice on interim.
That's why only the order is the order is
At present,
conditional.
my
At
lord.
present.
My-
If item number 24 and 25 are the same challenge to section
No,
16.
yeah, exactly in those item number 24 and 25, this validity of 16(4) is not under challenge. Or it is under challenge.
It is under challenge also.
Item 24.
And 25.
Yes, sir.
24 and 25, my lord, section 16(4) issue is there. But
have
there is
challenged
no
the-
challenge to the constitutional validity. It
You
is
have-
only on the interpretation, my lord.
Only on the interpretation.
Interpretation of section 16.
Will hear those petitions also along with this.
No, my lord, my case is entirely different from the challenge to the constitutional validity. Even if it is a issue of section 16(4), my arguments are totally different, my lord. May I place, my lord, what is my argument, my lord? And my lord, my argument.
24. Essentially, you have not challenged that validity of section 16(4) there, and you are simply asserting that retrospective amendment in rule 61 and 61.
Right, that is a adjunct, my lord, prayer
Yes.
to support my argument in relation to section 16(4). My lord, I may give up my that rule 61 retrospective challenge also. But my lord, kindly hear me for 2 minutes. What is my argument? Crux.
Mr. Counsel, then this matter is required to be considered by the single bench, not by the division bench, sir.
Yes,
That, my lord, my learned, because I am from Calcutta, so I am not aware of the procedure of.
It is for the single bench to consider, sir. Sir?
In cases the rules are
Where is that rule challenge to the rule?
That is, my lord, the prayer is page 43, 42, sorry.
42.
42, my lord, the third paragraph. To issue root, read or in the nature of mandamus or in the direction, retrospective amendment in rule 61.
Order or direction or direct the omission of rule 61 is unconstitutional, arbitrary and violative of article. If I do a response to it,
My lord, my lord, there is a prayer for, my lord, stay also, which my lord, which I inadvertently, I think it has been listed under the wrong heading that without stay. It is, my lord, there is a prayer for stay also on page 42.
page 42.
Yes.
There is no separate application for the stay.
But there is no separate application required, my lord.
अच्छा, इसमें they're not of appeal. Okay.
A separate petition for stay is not required.
Yes.
Indian lordship, there is no prayer for interim relief also.
No, that is there, my lord. The second paragraph on page 42.
42.
Yes, my lord.
To issue a nature of a mandamus and direction retrospective and unconstitutional and being violated for article so and so.
No, second paragraph from
Disposal
top.
of the Ramle keeping abeyance the effect and consequences of being shown on office. Let the response of the state make.
No, my lord, what I submit, allow me to submit for 5 minutes on the.
Will consider that, in fact, we'll consider whatever the interim relief also on the, by the next date of hearing, we are granting him a 2 weeks time to file response to the petition. We'll
But
consider
just,
it.
my lord, 1 minute, my lord, if I find my submit. So that my lord, my learned friend also knows as to what is my main crux of the argument, which is already, my lord, supported by the judgment of the Honorable Supreme Court. My main crux of the argument, my lord. My lord, the main crux of the argument is section 16(4). My lord, kindly have a look at section 16.
Appearance.
Yes.
My lord, section 16
of the GST Act?
GST Act, my lord, CGST Act. CGST or Assam GST, well, whichever, they are all identically worded.
Eligibility and condition for taking input tax.
Yes, my lord.
Please.
My lord, may I submit, my lord, before I read out the section to put the things in perspective? My lord, main crux of the argument is, my lord, the section 16 subsection 4 says that I am not entitled to take input tax credit beyond a particular date, beyond the return filing date of the month of the September following a financial year. So if suppose the financial year is 2018-19 and I don't take the input tax credit beyond the return to be filed for the month of September, then the credit is time barred. So, my lord, all the petitions which are there before your lordship and even before the Supreme Court, they are challenging the constitutional validity of section 16(4), saying that section 16 subsection 2 overrides section 16 subsection 4. And in any case, there should not have been a time limit. There cannot be a time limit for taking of the credit.
Fine.
So it is violative of Article 14 or Article 300A or Article 19(1)(g). So that is the main crux of the argument in the other petition. But my argument is that there are two stages, my lord. First stage is that I take the credit. Second stage is that I avail the credit. So the taking of the credit and availing of the credit are two different activities. I take credit in the books of accounts and availment takes place through the filing of the return. So if I've taken the credit in my books of accounts within the date, the due date prescribed in section 16(4),
September.
then I am in compliance with the requirement of section 16(4), just because there is a delay in filing of the return. So it is not that I am taking credit in return beyond in October return. I am taking credit in the month of return for filed for the month of
September.
For various months in the 18-19. So April to 19, I filed return belatedly because, my lord, because of the financial constraints, my lord. So I filed sometime around December 2020, which is beyond the due date prescribed in section 16(4). So, my lord, my humble submission is that, and it is also supported by a chartered accountant certificate.
Taking the credit and availing the credit are different things.
Different thing. And my lord, I will support my argument with the provision of the law, as well as, my lord, the judgment of the Honorable Supreme Court directly on the point, even though the context was different. But Honorable Supreme Court very categorically clarified that portal is only a facilitator. Portal is not the place where the event of taking of the input tax credit is happening. It is happening in your books of accounts. Because there the SSC was challenging the non-operational of the portal, and because of which he could not take the credit. So he was seeking revision of his return, saying that you did not make the portal operational, so I could not take the credit. So there the union argued that no, whether before the GST or after the GST, it is not that you are entirely dependent on the portal. You were always dependent on your books of accounts. That is where the self-assessment takes place. You do your own self-assessment. It is not that government is coming into the picture. You first do the self-assessment. After doing the self-assessment, you reflect your affairs in the various returns. My lord, the return may be income tax return. Return may be, my lord, today it is GST. Earlier, my lord, it was entry tax, VAT, service tax. So many returns, my lord, people file. But always the activity happens in the books of accounts. But suppose in the Income Tax Act, if any expenditure, my lord, there is a restriction placed that you cannot claim the expenditure beyond so and so date. I take the expenditure in my books of accounts. It is not that just because I am reflecting the details of my expenditure in the PL and balance sheet, which I am uploading in the return. Because, my lord, today, now those whose audited balance sheets are to be filed.
We understand that.
So, my lord,
So
I just,
because you
my
have
lord,
not availed the credit.
Yes.
Prior to the exact date, that doesn't mean that this availment will be refused by the department.
Yes, my lord. So,
Since you have already taken the credit in the account books.
yes, my lord.
That is material.
That is, my lord. That is, my lord, very simple argument, my lord, and it is supported by the section 16 itself and section 41, my lord. My lord, allow me to.
If that is the short controversy, let them file a reply to that. The counter to the writ petition will consider it for the interim relief also on the next date of hearing, and the counter is there. And we'll bound them to file within.
But till the next date, my lord, at least they should not proceed with the adjudication of the so-called notice.
We are granting him only 2-3 weeks time and nothing else.
Yes, ma'am. Yes, ma'am.
Okay, issue notice. Mr. Kyle, accept notice on behalf of
Respondent number 1, 2, 3.
respondent number 1, 2, and 3. And what about 4? GSTN.
GST, no, we have sub. They are all represented by the
State council.
standing council for the union.
In item 24, 1 and 3.
1 and 3.
Yes, ma'am.
1 and 3. Yes, 3 State of Assam.
Yes.
And Assistant Commissioner Union of India.
I am appearing.
And 4, you are appearing for
I can accept notice on behalf of Minister.
respondent number 4 also. Issue notice. Mr. So-and-so accepts notice on behalf of the respondent number 1 and 3. And Mr. So-and-so accept notice on behalf of the respondent number 2 and 4. Service is therefore complete. The learned counsel for the petitioners may file reply, a counter to the writ petitions by the next date of hearing. List on 15th of March. Is it convenient?
Well, your lordship said 2 weeks. 15th of March is almost a month.
Okay, 2 weeks. Suggest your.
Well, if it can be kept on, say, 5th of March, 5th of March, my lord. 5th of March.
So 5th of March.
6th of March, my lord. 6th of March.
6th of March 2024.
Great.
The prayer regarding the interim relief shall be considered on the next date of hearing.
Great.
They may direct to supply copy, so I can take.
Yes, we'll do.
Copy of the copy of the writ petition along with the requisite documents we supplied to the council for the respondents during the course of the day.
Great. Great.
It's about petitioners, respondents council.
Respondents.
Same order in item 25.
24 and 25, same order.
Tagged together.
Tagged together. Yes.
Item 21.
The last showcase, my lord. An order was passed with regard, bringing the instruction with regard to the Annexure M.
Annexure M, yes. What are your
My lord, the
instructions?
instructions are still awaited, my lord. Further 2
Why?
weeks I am bringing, my
Why?
lord.
You are supposed to take instructions. What action you have taken?
Well, I have taken the steps. The instructions are awaited, my lord. 1 week, my lord, is enough, my lord. 1 week.
You have to submit whether any
The report of the inquiry.
inquiry was conducted or not.
Yes, my lord. 1 week, my lord. Can it be taken on next Tuesday? my lord?
Learned counsel for the
State, my lord.
state raised last opportunity to apprise the court regarding the outcome of the letter dated 16/6/2023, bracket में annexure 1 in the present.
Annexure M.
Annexure M to the present PIL. List on so and so. After the.
God bless.
Item 23.
May I please judge your lordship? Lordship, petitioner before your lordship, my lord, legal survivor of my lord, legal heirs of the my lord principal Malad borrower, who is Malad deceased Malad father. So Malad, he took loan Malad in the year on 15 to 2019 Malad, 24 lakhs 50,000 Malad. And he was repaying Malad and on 31/5/2020 Malad, again Malad, that emergency guaranteed emergency credit line loan was also offered to him Malad. He has accepted the amount Malad. And during that period, Malad, immediately after 3 months, Malad, a notice was served upon him, Malad, that his debt has been classified as non-performing assets, Malad. At page 31 of annexure 4, Malad. Then, Malad, they have initiated, though they have the father of the petitioner, Malad, represented before the bank.
We have already gone through the facts.
Lordship.
You are aggrieved by the order passed by the DRT under section, in your petition under section 17.
My lord, this petition has been preferred, my lord, against the action of the respondents in not granting the time, my lord, because he has approached the bank, my lord, respondent bank,
Whether we
saying
can
for
issue-
time and again, my lord.
Whether we can issue amendments, grant them time.
Lordship, because he has represented, my lord, because he was at that point of time, he was only 22 years old, my lord, son. So, my lord,
You are
because
aggrieved, you have already approached the DRT.
Lordship.
DRT has rejected your claim. If you are aggrieved by that, file an appeal under section 17 to the tribunal. That's all. We are not going to interfere in this.
my lord, actually, we are ready with the payment now, my lord, because already,
It's
my
up
lord.
to you and the bank. We are not nowhere in the picture.
Only, my lord, we have repeatedly approached the bank, my lord, and now we have already, my lord, paid the 14 lakhs, already paid, my lord. Only 17 lakhs 33 amounts remain, my lord.
70 lakh,
17, 17, my lord.
17, you are
14
ready with
lakhs,
the
ready with the amount, my lord.
whole amount.
Whole amount, my lord.
Who is for the bank? Give them the money, they'll close the proceedings.
Rebalance or you will give it.
The 17 lakh 33,000 is due up to what date?
My lord,
Up to which date?
up to the date of, my lord, huh? Passing of the order, my lord.
Which order?
DRT's order, my lord.
11/1/2024.
11/1/2024. My lord, bank will calculate the remaining amount, my lord.
But I
During
think
this
so
period.
you ask for, and the thing is this, that your request is not accepted as the sale is completed, certificate of sale already issued and the accounts have been closed. So your property has already been put to sale.
Lordship, what happened, my lord, during pendency of SA, my lord, the first date of filing of the SA, my lord, the DRT or learned DRT passed the status quo order, my lord. At that point of time, my lord, sale deed was not executed, my lord. So, my lord,
If the
status
sale is
quo was
complete-
granted, my lord.
If the
So,
sale is complete, now we are not supposed to.
Lordship, a time from the very beginning, my lord, he has been approaching the bank, my lord. Bank proceeded, my lord, despite the fact that his father expired, my lord. During that period, my lord, COVID was there because his father was, my lord, businessman. And 31/5/2020 loan was given, my lord. He
Such
could not
matters,
repay the
you
debt, my
approach-
lord.
It's better you approach the tribunal.
বৰগোহাঁই আছে ষ্টেট বেংকৰ উকিল এছ বৰগোহাঁই 2,000 অলপ মাতি দিব চোন।
We'll take up the matter at 2.
Lordship, deeply obliged, deeply obliged.
The State Bank of India. To seek your instructions, we'll place it day after tomorrow. What she is saying that amount of rupees 17 lakh 33 lakh some amount is due. Whether the sale, the property is auctioned or not, or whether the bank is in position to have some settlement, She is ready to pay, the petitioners are ready to pay whole amount. Then you have supplied the copy.
I have given now, I'll give one copy, my lord.
Mr. So-and-so for State Bank of India. Please, a day's time to complete his instructions, list on so-and-so,
By showing his name in the.
by showing his name in the call list.
Lordship, in that case, your lordship, I can communicate the matter to the State Bank of India because we have panel advocates. So we are not standing counsel. That is the issue, your lordship.
The requisite documents we इसको सीधा यही लिखना वापस से redraft the order sheet. The requisite documents we supplied to Mr. So and so,
Panel advocate
for State Bank of India. Mr. So and so may complete his instructions by आज क्या तारीख हुई है? 21st of February, list on 21st of February.
Oblige me.
Again, otherwise, appeal provision is there.
Lordship.
Simply granting indulgence on account of that, you are ready to deposit the whole money.
Lordship.
Yes.
Lordship. Deeply obliged.
Item 29.
Who is calling for the respondent?
Petitioner
Supposed to place on record the draft rules.
Yes, my lord, that draft rule I have wrote. But may I submit one thing, my lord? Otherwise, my lord, the matter pertains to the single bench, my lord, because they have not challenged any rules. They
The
have not.
single judge has already referred the matter to.
Yes, my lord. Yes, my lord. Sir. I have got the copy of the draft case.
Madam, we are not on the draft rule, madam. We have already on the existing rules, madam, 1991 rules, madam. The rule was framed, my lord, under Article 309 of the Constitution of India. Madam. Kindly have a look, madam. Page 33, madam. Page 33, madam.
think so the draft rule were asked to produce on.
Draft rule was prepared by the since 2018, my lord.
These are the
But they have-
2023 rules.
Yes, my lord. Because, my lord,
They have said that, my lord, they are preparing the draft rule since 2018. But we are, my lord, we are, my lord, seeking relief on the basis of the rules, my lord. That was framed in the year 1991, my lord. There are the existing rules, my lord.
Yeah, वो एक कैटेगरी ऑफ नाचेस को सेलिब्रेट करता है। मुझे आइडिया भी नहीं। मुझे लगता है सिविल जज का ये ऑब्जर्वेशन तो कितना आरोपी दे आर सिंपली maybe they are not challenging the they are also mediated. These are actually symbolic. Ultimately, it's the belief that what is the relief you are seeking here?
To rectify the anomalies that has been committed by
What is the
the.
anomaly?
Having BSc degree, madam. That is the anomaly, madam. We have,
My lord.
we are still working, madam, without any proof, madam.
My lord,
The ROP has, madam, removed our proof, madam.
the feeder cadre is the
My
staff
lord.
nurse, my lord.
Madam, kindly have a look, page 33, kindly have a look,
One
madam.
by one, please.
Yes.
Yes, you mentioned it, yes.
The feeder cadre is the staff nurse. So they are working as staff nurse. So some of the staff nurse having graduate degree, my lord. Having graduate degree, they approached the pay anomaly committee, and pay anomaly committee granted one extra grade pay to the staff nurse having BSc degree, my lord, graduate degree. So the other associate, the nurses association, who is staff nurse, they are before your lordship praying for the same grade pay.
They are not graduate.
No, my lord. So the pay anomaly committee granted, my lord, great pay to the staff nurse having graduate degree, my lord. At an enhanced rate. Yeah.
But the basic qualification for to become a staff nurse is, my lord, either having BSc degree or GNM degree.
That's right.
My lord.
But once.
Even my lord, ROP
Pay
2010,
anomaly
even ROP 2010, my
Pay
lord.
anomaly committee,
My lord.
if has decided to grant one grade, grade increment to the persons who are having graduate degree with them.
No,
So
no, my lord, pay anomaly committee report, my lord. Kindly have a look, my lord, page 44, my lord.
44.
My lord.
What is that?
Three organizations have approached this, my lord, pay anomaly committee, my lord. That is 44, page 44, my lord. One, all GNM staff nurse, my lord. Their claim is to, my lord, anomaly committee resolved that the Health and Family Welfare Department may examine the claim, my lord. They have not decided, my lord.
Where is that?
Page 44, my lord.
Page 44, yes.
My lord. But first, my lord, all GNM staff nurses,
Yes.
they claim that their claim is to allow equal benefits of salary advance increment availed by the staff nurse. The remarks is that, my lord, the anomaly committee resolved that Health and Family Welfare Department may examine the claim. Even, my lord, the Health and Family Welfare Department has filed an affidavit, but at page 53 of my lord, affidavit filed by the, my lord.
What is their assertion?
My lord.
What is their assertion?
They say that nomenclature of entry post to the nursing service health and department will the staff nurse irrespective of degree and diploma. That is the. They have on road matter. They said page 54.
15?
54. Start from page 53, madam.
Fifty-three. Page 53 you are referring to.
54, madam. For particular is 54. Madam. Now, my association, the members of the association is working without any push, madam.
Without any?
Any push, madam. Now, staff nurse is, according to ROP, staff nurse means, madam, only who have BSc degree, madam, having BSc nursing degree. The others, madam, who have GNM degree, madam, they have no post, madam. After the ROP 2017, madam. We are still working, madam, without any post, madam. Even on ROP 2010, madam, there is no discrimination, madam.
What is this annexure two is? This 31st of July 2020 is?
Annexure two, my lord. Yes, my lord.
It says what?
My lord, the relevant portion is down below clause one, my lord. Point number one, my lord. The issue relating to the post of staff nurse, same post, same pay. The matter is under process for government file number so and so. And presently the file is under the appraisal of the finance department for recommendation and cabinet decision. The concerned health and family welfare department will follow up the outcome in this regard. So our department is trying to resolve the issue, my lord, by
18/7/2020, this meeting, minutes of the meeting.
yes, my lord. Yes, my lord. Thereafter, my lord, for
Almost
some,
3.5 years.
Yes,
more
my lord.
than 3.5 years. What happened then?
thereafter, in the meantime, for some time, the health department was busy in handling the pandemic situation, my lord. And thereafter, my lord, we have moved the file to the concerned finance department. On many occasions, they have again suggested some to be my lord, some shortcomings in the draft rules, my lord. So that has been again rectified, my lord. Again, it has been submitted to the, now this final draft service rule has been submitted to the finance department. Here, my lord, that staff nurse post, there is no discrimination, whether they are having the DNM degree or the graduate degree.
Which is that provision?
My lord, your lordship may kindly come to page, my lord, 13, my lord. Page 13, my lord.
Private case or we should post post equality. Yes, so the जो पे है हमारा वो
Page 13, my lord.
Page 13, yes.
Yes,
staff
my lord.
nurse.
Yes, that is staff nurse. Pay structure will be the same for essential qualification, my lord, GNM, BSc, MSc, my lord. So now only one pay scale, my lord, for the staff nurse having GNM degree or graduate degree, my lord.
Then what remains in this case?
My lord, it has not been finalized. Now it is pending the concurrence before the finance department, my lord.
That's the only relief you have.
No, we are seeking relief from 2017, my lord. Now they are preparing my draft rules, my lord. We are not on the draft rule, my lord. We are seeking relief on the rules, my lord. That still exists, my lord.
That's
1991 rules, my lord.
Mr. Advocate, that's another thing you are seeking relief since 2017 that you will consider. But suppose if these draft.
They are preparing this draft rule since 2018.
Just if these draft rules are approved, then whatever your grievance, as on today, that is redressed.
But now we are working, my lord.
That is going to be redressed.
Well, then, my lord, your lordship will direct the respondents to fix the date for effecting date, my lord. Otherwise, my lord, they are again pending, my lord, since 10.
What time you will get the approval of these draft rules?
My lord, it is with the finance department.
As per instruction, it will take 4 weeks time to take a decision.
You'll approve these or whatever it may be.
Yes, Lordship, it is under consideration because the Lordship.
Before the finance department.
Yes, so 4 weeks time as per instruction, the department has asked for 4 weeks time to give an approval and to assess the proposal that has been sent by the draft rules.
Okay. Learned concept of the respondents have submitted that. The grievance raised by the petitioners in this petition would be resolved with the approval of the draft rules. With the approval of the draft rules of Assam, the Assam Nursing Service Rules 2023. Full stop. And council appearing for the finance department has submitted that the draft rules are under consideration with the finance department. And it may take about 4 weeks to take a decision regarding approval of those draft rules. Stop taking into consideration the above spec situation, we deem it appropriate to list this rate petition after 6 weeks. By the next date of hearing, the council for the finance department may submit a status report regarding the regarding the approval of the draft rules.
Obliged, my lord.
Item 30.
Yes.
Lordship, the issue that I have raised before this honorable court is that ignoring public protest and in violation of the Assam Excise Rule 2016, the Excise Department has taken an initiative to grant license to establish a wine shop in a residential area. Lordship, they have violated 3 rules while taking initiative: Rule 279, Rule 294, and Rule
Size
295.
This is.
Lordship, may peruse the rule 279 first. It is in,
Which is the provision wherein this license are being issued?
no, yet to be issued, Lordship.
Nee, which is the authority?
Excise Department.
Excise Department, which is the authority? Excise Department.
Superintendent of-
Commissioner and so many.
Superintendent of Excise.
Superintendent of Exercise.
Commissioner, Deputy Commissioner will be. Deputy Commissioner is the main authority in the district law.
There is no deputy commissioner.
There is a commissioner. There is a commissioner. Second.
Without considering the public. Distribution is 294. Compared with when it is in public.
Have they issued any license till date?
No, no.
Then?
It is under process.
You have not issued any license for that particular area.
Till now, it's not.
What is your response to this PIL?
Nursing, in this case, first and second inquiry has been already been conducted. After that, third inquiry has been conducted while petitioner has raised some disputed questions regarding some DAG numbers and pattern numbers and
Regarding some?
DAG numbers of some residents. But after the third inquiry, which I have annexed in my second affidavit, it is found that 8 DAG numbers where he's stated about the resident which is within the purview of 75 meters radius of the wine shop. Those complainants have already been withdrawn their complaints by submitting their withdrawal application. I have annexed
Page 67.
affidavit notice.
Friend is referring page 67 of our affidavit in opposition.
67, Lordship, I have annexed here. 8 page 63, Lordship. And sorry, 62, Lordship, 63. Annexure is 8 page. Annexure is 8 page 69 of my second affidavit. Affidavit is filed. On my second affidavit, it is at page 69.
So what happened to this report now?
Lordship.
You have submitted this report, this page 67.
Oh, yes,
Inquiry
Lordship.
report you have submitted.
Third inquiry report is at page
67, the second inquiry report of December 13, 2022.
No, Lordship, this is third inquiry report.
Third inquiry report.
Yes, sir.
You have submitted it to the Superintendent of Excise Gopalpara.
Gwalpara.
Gwalpara. Then what happened in that report?
Lordship, during this period of inquiry, it is found that one meeting was held in 7th of August 2022 in Haulapara Mandir in the presence of 112 people of Haulapara locality and adopted a resolution in favor of establishment of the IMFL on-site. And that stamp copy has been forwarded to the Deputy Commissioner of Gwalpara on 17th of August 2022 for considering the proposal of IMFL launch of Kampar at Haulapara on the plot of land covered by DAG number 537, which is mentioned by the petitioner in his affidavit wrongly, DAG number 676 in para number 6, in his affidavit in reply, but it should be 537, that number. And all those complainants which he mentioned in his affidavit in para number 6, Yusuf Ali, Navanita Das, and Urvasi Radha, all have withdrawn their complaints by submitting a withdrawal application. And one from Ghulam Mustafa Akanda, who has the house in that plot of land in that Dagnam, it is in what he mentioned in his affidavit. In that number, he has a house, but he has not staying there. He has rented his house to another person, but that person has also not also have no complaint. And Abdul Aziz Mandal, who has filed this PIL, he is not coming with a clean hand. Kindly see at page 79 of to file this PIL. 79 of my second affidavit. It is a public resolution, Lordship. Public resolution in favor of proposal of I have locked up. Resolution number 3. Kindly see. Today, in today's meeting, I have found that complainant Abdul Aziz Mandal, son of Jalaluddin, District Gwalpara, Assam, is a government servant. He is working in the post of ZRS. Ram Rozer Sahayak, but in the affidavit, he himself has stated that he is a businessman, which is a false and fabricated. We the general public hold that such a person who gave false identity before Honorable High Court is an offender. Therefore, we pray before Honorable Court to take legal action against this person, against such person. And in resolution number 4, Lord, kindly see, today's meeting have decided to inform the authority against complainant Abdul Aziz Mandal, son of Jalaluddin, post office and police station, Lakhimpur district, Gwalpara, Assam. Earlier also, Abdul Aziz Mandal was working as an accountant in the education department in the office of the ward Lakhimpur, but he was dismissed for misappropriation of the government money. Therefore, the authorities should take against this person, against such person.
Even though if he is dismissed for misappropriation of money, he can very well raise objection regarding opening of the liquor shop.
Yes, he has made objection.
He can very well raise that. That can't be a ground case since he has been dismissed from the service. Therefore, is whatever reasonable demand is not liable to be considered. That can't be the reason.
And Lordship, I can see in my third inquiry.
So the department has taken a decision to grant the IMFL license in favor of whatever the person who is asking for on that said location.
No decision has been. Only an application has been. There are grievances that the application, they're in the process of giving the license and the objections of the public. Within the.
And you are following that whatever the process is.
The private respondent, also the application.
Is the applicant.
He's only submitted an application. That has not even been allowed. We've not been granted the license.
One thing,
They've
Lordship,
made an application and paid the license.
First, second, and third inquiry, all these entries have been conducted in accordance with Rule 289(2), 295(3), and 294. All these Assam Excise rule has been complied with.
Complied with.
Yes,
what do you want to say?
Lordship, first of all, I want to make one thing clear that I have nothing to say about the applicant because he is our next door neighbor. If the rule permits, he may be allowed to open the shop. The issue that I have raised, that Rule 279 says that they are in the place where the proposal has been taken to establish a IMFL on shop or own shop, there must be a proven demand from the class of drinkers that such action is necessary in the public interest. And it is connected with the rule 294, that says that authority before granting license has to conduct the inquiry to establish that such action is necessary in the public interest. The first time coming that my respectful submission is that in compliance with the rule 294 and rule 279 has been conducted.
Now they have considered your objection, whatever the objection.
I'm coming. Objection is second part, Lordship. I'm coming. I will address the issue. First, I'm coming on the rule objection deal with the rule 295. And I am submitting on the rule 294, which is about the inquiry that shall establish that proposed action to establish a liquor shop is necessary in the public interest.
It is in public interest.
Ah,
No objection, Lord.
I get confused, Lordship.
You are confused or you are confusing us.
No, I'm trying to explain the issue.
Madam, let him explain.
The Lordship, the page 67. With reference to the subject cited above, and as directed, I have the honor to state that an inquiry have been done by the undersigned in connection with the affidavit submitted by Abdul Aziz Mandal, so and so, so and so. This is important. First, during the period of inquiry, it is found that a meeting was held on 7/8/2022 at 2 p.m. in the premises of Halupara Holy Mandir in presence of 112 number of people of Halupara locality and adopted resolution in favor of the establishment of opening of the IMFL shop. This resolution, they are relying that it is an inquiry report which is conducted in compliance with the rule 294. And this resolution itself speaks that it is a public meeting organized by the applicant and the persons who are present in the said public meeting. They were invited by the applicant himself, who is the applicant of the wine shop. So it cannot be considered as a report.
So what is the manner of? What is the manner?
Manner, I may have permission to read the rule 294, Lordship.
Read.
The opening, shifting, and closure of any licensed premises shall be done by the district collector with the previous sanction of the state government. Such opening, shifting, and closure shall not be granted unless it has been satisfactorily established by the local inquiry that proposed action is necessary in the public interest. Local inquiry has to be conducted by the authority who is authorized to
What is
issue
the manner
license.
of conducting that inquiry? 120 persons assembled there. They have ascertained their wish and they
Yes.
said, "Okay, yes, it's okay
It
to
is
open a liquor shop there."
I am not aware about the manner because it is up to the authority. They will decide in what manner they are going to conduct.
So they have decided this.
They have decided I don't know whether they are going to conduct, but it is a public meeting, Lordship. I may be allowed to. It is a public meeting, signed, resolution adopted and signed by the 112 people who are invited by the applicant.
From where we get this? They are invited by that.
This is itself there in the report. I'll
Obviously, if he is interested in opening a shop, he'll assemble the
Just that
local
tomorrow,
people
Lordship.
and ascertain their wish. If you are objecting to it, you may also assemble the local people.
No,
and
it is
get
not
their
the
wish.
manner. Then
Ascertain.
tomorrow I may organize a 1,000 people. They
Yeah.
will submit a memorandum, and day after tomorrow they will organize another 1,000 people. So system will go on. So it
So
cannot be allowed
ultimately
to
the
go on.
license will not be granted. Let the system may go on.
There is of course, there is a inbuilt mechanism. The authority may know what is the mechanism to conduct the inquiry, but a public meeting organized and conducted by the applicant himself, who is the respondent of the case, cannot be considered as a
Yes.
Yes, Lordship, this is one point. My respectful submission is that This resolution is adopted by some people who are invited by the applicant himself. So Lordship will consider that aspect, and my second submission is that regarding public complaint. In the page number 68, Lordship may peruse the affidavit.
Yes.
The Jainal Abedin, complainant at serial number 18 does not reside there, though he has a residence within the radius of 75 meters. That is, the complainant has a residence within the radius of 75 meters. And they have ignored because the person is not residing at his residence. And the rule, what the rule says that occupier, owner, or
Yes, we
resident.
understand now. Take now. This writ petition in the form of public interest litigation is filed by the petitioner, essentially the petitioner seeking a relief that the respondent, authorities of the excise department be directed not to issue a Indian-made foreign liquor IMFL on shop at Lakhipur town, Golapada district, Gwalpada district.
On license.
IMFL on license on the on shop. On license at Lakhipur town, Gwalpada district without addressing the public objection and conducting a local inquiry as provided under Rule 294, 295, 294 and 295 of Assam Excise Rules 2016. Full stop. Learned Counsel appearing for the Excise Department has submitted that the department will issue a license of IMFL at the location, at the concerned location only after following the procedure prescribed under the Assam Excise Rules 2016, particularly under Rule 295 and 294 and 295 of Rules of 2016. Full stop. In view of the categorical statement made by the Counsel for the Excise Department, we don't we are of the view that no further order is required to be passed in this writ petition. However, if the decision taken by the excise authorities is adverse to the petitioner, he is free to avail appropriate remedy available to him under the law.
Lordship, one more submission is that
What submission?
subject to the approval of this court, Lordship, that in fact, in this excise rule, there is no other remedy. If once the complaint is submitted, it is not considered.
That's why only we kept it open. We kept it open, whatever the available remedy available, you can avail that remedy. If that remedy is only writ petition, you can very well come in the writ petition. We have kept it open. We have not confined it.
Once, Lordship, once the license is issued without addressing the grievance raised by the
And
petitioner,
you can very well challenge that action of the respondent excise department by availing whatever remedy available to him and available to you under the law, including the filing of writ petition. We have kept it open.
my understanding, it may be wrong, but once the license is issued, it is crystal clear
Once the
that
license is issued, and if you are aggrieved by that, then certainly you can approach, avail remedy available to you under the law, including filing of writ petition.
That is absolutely all right, Lordship. I understand this point, but my,
Then what is the point to argue?
no, no,
again?
my submission, last submission, Lordship.
Yes.
Before issuance of the license, they may verify and they may consider the objection raised by say certain people.
Naturally, 294 or 295, what it says? 294 and 295 rules mandates what?
Mandate the inquiry has to be conducted and
To consider the objections.
yes,
They're saying they'll comply with that.
Yes, sir.
but
But what?
that they have admitted that the person is residing within 75-meter radius.
We have not taken into consideration at all. We have simply noted her undertaking that they will comply with the rules as provided under the provisions as provided under the Assam rules. That's all. If they are not complying with it, again challenge that.
They have admitted itself, Lordship, they are in the affidavit, they are.
We have not taken into consideration whatever the admission or non-admission.
All right.
Item 31.
For it to be done in a specified time period, madam. My life.
They'll do it.
Pending since 2020.
You may also avail appropriate remedy available to you under the.
Lordship, within 1 month, I will.
It is also. Because in this matter, the respondent number +9 has filed affidavit today, Lord. I need some time to go through it.
You are
And
going
even
to,
regular, sir.
you are going to implement the findings of that commission or not?
Yes, madam, definitely, madam. In fact,
Have you implemented it?
my lord, that report from every district is awaited, my lord. That I can place, my lord, if some time is given. my lord.
Report from?
Every district, my lord, district authorities have been directed to conduct the inquiries and all.
Look here, learned concept of the petitioner has submitted that he is in receipt of a counter filed on behalf of the.
Respondent number 9, my lord.
Respondent number 9, he placed some time to complete his instructions list on third, so.
Item 32.
Lordship, I have received the affidavit from respondent number 4 and 5 today. Whether that affidavit is on record, Lordship.
Yes.
Lordship, I have received an affidavit from respondent number 4 and 5 today. Lordship, I may be given time to find a counter.
Yeah, learned concept of the.
Lordship, today it has been filed. Today it has been filed, Lordship. That is not on the record, Lordship.
Yeah. And concept of the petitioner has submitted that he is in receipt of the counter file on behalf of the respondent number 4 and 5. Today only, he placed some time to complete his instructions list on.
Item 33.
Item number 33.
May I please, your lordship? My lord, this is a continuation of a series of PIL, my lord, which has been, my lord, disposed of by this honorable court with a direction, my lord, that a judicial inquiry committee by of a retired judge of our honorable high court should be constituted, my lord.
Mr. Bhuya, now statutes have come in the central as well as the state.
My lord.
So what is the need for this PIL? This has become infractious.
Yes.
No, my lord, the statute, then my lord, I will, next week, my lord, may be taken up.
Draw with liberty to approach as and when appropriate cause of action arises.
No,
Now
no,
your
no.
grievance is taken care of. They have done it because of this.
No, my
Because of
lord,
it,
grievance has not been, my lord, fully taken care of. Our,
My lord,
One
our,
statute is already
My lord.
adopted, addressing all the, malpractices or whatever the shortcomings in the competitive exams are there.
my lord.
So what remains in this petition?
My lord, there are certain issues, my lord, which you have raised, my lord, regarding
Go
the,
through that act.
my lord, I have not gone through, my lord, that a week's time may kindly be given, my lord, I will go through, and on next date, my lord, may dispose of, my lord. I'll go through, my lord. My lord.
Yes. In view of the fact that a act has already been enacted addressing the issues raised in this PIL petition, we are of the view that nothing survives in this writ petition.
My lord, what is disposing of, my lord?
However, learned concept of the petitioner seeks some time to go through the enactment on this subject. Just after a week.
Or 10 days time, maybe kindly be given.
10 days.
My lord. Obliged, my lord.
Item 37.
May I please your lordship? My learned friend is supposed to. give
Lordship,
the-
I am appearing on behalf of Mr. D. Nath, Lordship, due to some personal difficulty, he is not able to appear today.
Time.
Let it be posted after a week, Lordship.
At the request of the learned counsel of the respondent, in this matter, after a week,
Lordship. Yeah. Okay.
Item 38.
I may be allowed to file reply against the affidavit of the despot number 4, my lord. Sometimes I give given.
My lord, my learned friend may be granted the time. My lord, my submission is, my lord, here the amendment of the rule is put to challenge.
Yes.
Without, my lord, any ground. Merely
Then
the
your
amendment,
lordship
my
will
lord,
accept.
come in his way for promotion, my lord. That cannot be a ground, my lord, for challenging the amendment. Now the requirement is graduation, my lord. He is not a graduate, and therefore, my lord, his case was not considered for promotion.
Then your lordship should also will examine, my lord, because I am a grade 4. Grade 4 requires graduate qualification, whereas
It has to be challenged on some constitutional ground.
LD assistant requires no graduation.
No, but Mr. Talukdar, there is way of reading down the rules also if a case is made out. It's not necessary that every time the rules have to be.
Yes, correct.
declared.
Lordship is correct.
Rules can be read down also.
Rules can be read. My lord, what I'm trying to submit, my lord, there must be some pleadings to the effect, my lord, that for this reason, my lord, the rule is bad, the amendment is bad. I don't find any reason. What he says, my lord.
Pleadings, he will do it later.
Yes, my lord.
Now he has filed it.
I leave it to your lordship.
Again, learned counsel, the
Correct, ma'am.
petitioner has submitted that he is in receipt of the counter filed on behalf of the respondents. He placed some time to go through the same. Mr.
Obliged.
39.
May I please your lordship? My senior is out of station, lordship. Matter may be adjourned for the day. His name is shown in the cause list too.
His name is not shown in the cause list.
Shown in the cause list.
On leave. Acha, on leave.
May I please your lordship, not adjourn for the day, lordship. My senior is not physically well, me also, lordship.
What do you want?
March, lordship, second do.
So, date जो भी आप
Problem.
Item 41.
The petitioner husband, my lord, was 38 years. He was kidnapped by 4 armed persons. The SIT was constituted on the basis of an order passed by this court. And ultimately, my lord, charge sheet has been filed. And the charge sheet, my lord, all the police personnel who have kidnapped, my lord, these are recorded. So we have filed a petition for compensation. Because at the time of his death, my lord, he had taken four trucks, my lord, on loan from the bank. And he was paying about 3,85,000 per month, 3,59,000 per month. So that appropriate compensation has to be determined in this case.
What is your reply, Mr.?
My lord, some incomplete instruction I have received. To get the complete instruction, Lordship, give me some more time.
Incomplete, what incomplete?
My lord, regarding compensation part, I have not received.
No, you are contemplating to learn some.
No, yes, we have to obtain some instruction from the government. So what they propose.
Those are the complete instructions.
Yes.
But what are the incomplete instructions?
Incomplete, my lord, some paragraphs comment they have sent, but not, my lord, stated about this compensation part, whether the state is proposing any compensation or not. As per my lord, compensation like section 3.
There are Supreme Court judgments. We can direct you to pay the compensation.
Lordship, before that.
It is a case
Yes.
of a custodial death.
Before that, Lordship, give me one opportunity.
Police themselves, my lord, picked him up. All the 5 police officers, my lord, they picked him up. Then ultimately he was
No,
shot
that
at.
case is, my lord, completed.
That is
Investigation
the
completed.
charge
Yes,
sheet.
that part is already over. But regarding compensation, we have to get some instruction.
Okay. Mr. So-and-so put in appearance on behalf of all the respondents.
My lord.
All the respondents, it takes some time to file response to the petition time frame for is granted. How much time would you like to have?
2 weeks, my lord.
You can't file it within 2 weeks, Mr. Bora. Then you will ask for adjournment.
Anyway, Lordship, but 3, my lord, my learned friend appearing.
Oh, 3.
3, my learned friend appearing. He is from North Kasa.
You are for the, Mr. So-and-so for respondent number 1 to 4 and 5.
I'm appearing for 1 to 4 and 5.
And Mr. So-and-so put in appearance on behalf of the respondent number 3. The counsel for the respondents place for granted time to file counter to the writ petition. List on 11th of March.
Lordship,
11th of March.
I am deeply obliged.
Item 42.
Please, your lordships. My lord, in this petition, we have challenged a section in the Wildlife Protection Act.
For starting the matter, my lord, I received instruction, I also prepared the affidavit on behalf of respondent number 3, State of Arunachal Pradesh. I need my lord to time to file the affidavit. And my instruction is also there, I draft affidavit also with it. I have got the officer from the Arunachal Pradesh. It is, I am paying for the state of Arunachal.
You are for the state?
Yes, sir.
So difficulty, I may also be allowed to file my rejoinder to their affidavit.
A copy of the, my lord, affidavit in opposition filed by the.
I'll supply him to him right
and
now.
also by the.
Okay. Mr. So-and-so for respondent.
NMD subject. NMD subject.
Mr. So-and-so for respondent number 3. Place for and granted time to file counter to the petition. Counsel for the petitioner also place some time to file rejoinder to the counter filed on behalf of the respondent. One. List on.
I have filed my rejoinder already to respond
You
to
already
one,
filed?
respondent number 1's affidavit. I have already filed my rejoinder to their states.
Let them file, then only
Yes.
the question of rejoinder would come.
No difficulties, sir.
Okay, time plates for injection. 18-3.
Could it be 22nd, your lordship? subject to
22nd.
Obliged.
Item 43.
May please, your lordship. Regarding promotion of the director of economic affairs, what happened actually? In this case, no any stay order is passed. Your lordship, respondent number already filed a affidavit in reply. I have received. Yeah, your lordship may kindly be allowed to filing the additional affidavit in reply on the 29th February. Matter is a very urgent. Why it is urgent? now are going to be the initiated promotion of the Director of Economics and Statistics. 29 may kindly be fixed. In the meantime, I'm going to file the additional affidavit.
It's from 29th of February.
29th February. Must be.
Supplementary list, item 45 for admission. Wait for a minute.
Understanding.
Yes.
Item 45.
This appeal filed, my lord, challenging the order dated 29/1/2024, but on a single judgment. Thereby, my lord, writ petition filed by writ petitioners allowed, my lord, and the settlement made in my favor has been set aside.
In a cancelled tender.
A cancel tender. I'm coming to that, my lord. The factual background is that, my lord, on 2/5/2023, tender notice was circulated, my lord, for settlement of
On 2/5.
2023. That you'll also find page 23.
2/5/2023.
23, my lord.
Yes.
A tender notice was circulated by the respondent of 5 and 6 for settlement of the market mean house ponds under Lahorikar Anchalik Panchayat, my lord. In response to that, my lord, tender notice, 13 bidders, including the appellant and the writ petitioner, respond number 789. They participate in the tender process. Thereafter, completed statement has been prepared by the
What is wrong with the impugned order?
my lord, actually, my lord, in a competitive statement, so far as the impugned order is concerned, my lord. So far as the initial tender notice that has not been cancelled, simply on 23/6/2023, respond number 3, by convening a meeting, took decision that will issue fresh tender. And thereafter, my lord, again, by convening a meeting on 27/6/2023, that decision taken on 23/6/2024 issuance of fresh tender, retender, my that has been cancelled. Subsequent, that has been cancelled. Then again, settlement has been made in my favor pursuant to the initial tender notice. I being emerged as the highest valid bid, my lord. The Lana Single Judge says, my lord, since the settlement has been made on the basis of the cancelled tender process, so it is set aside, my lord. During the pendency of the before Lana Single Judge state did not find affidavit in opposition, my lord. So when the private response number is concerned, my lord, after filing affidavit, they appeared, and second day, they disposed of, my lord. So far as the, my lord, clause 10, terms and conditions is enumerated in the clause 10 of tender notice clearly says the when the retender can be issued. It says, my lord, if free valid tenders are not received for any markets, or if the bid value of any market is considered to be not adequate, then the fresh quotation will be invited, my lord. So far as the rule 4710 of the Assam Panchayat and Financial Law 2002 clearly says, my lord, tender of the highest bidder shall be accepted, my lord. I being highest bidder, the settlement ought to have made
in my favor, my lord, but without settling, my lord, they issued a short retender notice that has subsequently cancelled. Again, settlement has been made in my favor. I being the highest valid bid, my lord. That page 102, my lord, it is the, my lord, order wherein, my lord, retender issued on 23 has been cancelled and decided to settle in my favor, pursuant to the initial tender notice.
Para number 6 of the impugned judgment. The concept for the respondents, you are including you.
I'm private respondents.
Respondents, all the respondents submits that there is no dispute with regard to the facts in question in as much as the earlier tender notice dated 2/5/23 was cancelled in lieu of the same subsequent tender notice 23/6/2000 was published. It is also not disputed that prior to the last date of submission bids in terms of the subsequent tender notice on 28/6/2000, the state respondents have selected the respondent number 7 as the successful tender for settlement of the market in terms of the earlier cancelled tender 2/5/2023. Where you have argued before the single judge that this tender notice dated 23/6/2023 has also been cancelled. And the committee has decided that will go as per the earlier tender order. Where is that?
My
You have
lord,
not mentioned this fact in before the London single judge.
no, since my lord, we did not get any reasonable opposition to file affidavit in opposition.
So that is.
Yeah, page,
Why you have not filed the
page 44. It is a retender notice. Retender notice, nowhere it is decided that initial tender is cancelled. Page 44.
44.
Yes, my lord, it is a retender notice, short retender notice. Page 44.
44, yes.
Yes, these are short retender notice. They are married, my lord.
This is 23rd of June 2023.
23, my lord.
Yes.
It is for the information of all the public in general that short quotation are hereby invited for giving settlement of the below named market under the Lahori Financial Panchayat for 1 year for the financial 2022-2024. With effect from so and so as per the instruction of the letter number so and so, so and so, so and so. And as per the decision taken by the General Standing Committee of the Modigaon Jilla Parishad in its meeting dated 23/6/2023.
Yes.
But is nowhere it is mentioned that settlement process initiated by tender notice dated 2/5/2023 that has been cancelled.
You should have challenged this.
My lord, immediately after 3 days, the date has been cancelled.
That has been cancelled. Where is that?
Yeah, Malik, kindly page 102.
What?
102.
102.
Yes. This 23, 27. Page 23. It is a reply while my lord responding to the RTR application, the respond number 2 is.
102, yes. What is it?
In respect of your application dated you submitted through the letter mentioned in the aforesaid reference, seeking information on various matters under right to information 2025, I would like to inform you that as per the decision taken by the General Standing Committee in its meeting dated 23/6/2023, the concerned executive officer was informed to take necessary measure to invite so tender notice for giving the settlement of Borali Mari weekly market and Borali Mari daily market. But as per the suggestion put forwarded by the members of the General Standing Committee and in pursuance of the decision taken by the General Standing Committee in its meeting dated 27/6/2023, the said short tender notice was cancelled.
Again, read
Subsequent
further, read further.
And it was proposed to give settlement of the market to the highest bidder as per the tender notice 15/6/2023, initiated by tender notice 2/3/2023.
15/6/2023.
No, no, 15/6/2023.
You applied in pursuance of the tender 25/2023.
No, my lord, it is,
What is this
no,
15/6/2023?
it is confusing, my lord, because in the 2/5/2023, it is mentioned that last date of submission of tender was 15/6/2023.
To cancel it, नया tender लगा है, तो उसको मतलब
Where is the meeting? 27/6/2023. This decision of the General Standing Committee meeting dated 26/2023 is where? It is on record.
No, it's not on record, my lord.
So then, what is this? This 18th of August 2023, you are referring to a letter. Where is the decision whereby they decided to cancel the this tender process dated 23/6/2023? Where is that order?
No, there is a, we have, only the department can produce that report. It is a departmental matter.
That's and if you are agreed that without cancellation of the earlier tender process dated 2/5/2023.
23/6.
2/5/2023, in pursuance to that you have submitted the bid.
Yeah, 2/5/2023, yes.
So your contention is that this tender notice dated 23rd of June 2023 was issued without cancellation of the earlier tender process. You should have come before this court.
Well, how can I immediately after
How
20
can I come? You are
Like
supposed to.
on 27, my lord, it has been cancelled.
Where is that decision, sir?
Yeah, this is my lord, page 102, my lord.
102 is letter dated 18th of August 2023.
18/1, my lord, because
Show us the decision. Where is that decision?
that only, my lord, the department can produce that decision.
Then what you will do? You have to prove your case. And you have not even argued before the learned single judge this point. File a review petition if you are.
I know that particular document was before a learned single judge. It was annexed by the three petitioners. It was their documents. That was before a learned single judge.
Somebody has to argue.
You
are the best person to argue.
That particular
You
document
have to defend your tender or whatever the bid.
that particular document brought before a learned single judge says that, my lord. It is written, my lord. That there is no cancellation of the subsequent tender notice dated 23/6/2023.
Here it is not we are not in advisory jurisdiction, but at least what we feel you should file a review petition if you are these whatever the documents which you are showing and escape to the notice of the learned single judge, file a review petition. Not a case of appeal, sir.
My lord,
There is no mention regarding whatever you are arguing here. You have not made any such argument before the learned single judge.
that was my lord, that argument was made. That particular document brought before a learned single judge by the petitioner itself. Thereafter, I brought this particular document before learned single judge. But learned single judge, my lord, in a para 9, last line, my lord, para 9 of the learned, para 9, my last line, my lord. Second line from the bottom, though there is no cancellation of the subsequent tender notice dated 23/6/2023.
Yes. So, this is a wrong finding. This is a wrong finding by the learned single judge. Error apparent on the face of the record. File a review petition. You don't find any reason to give such a strange look. Okay, what you are referring to, it's not.
The question before learning whether the process adopted or decision taken by tender authority is my lord nullified. But
Basically, on the
arbitrary
face of it is nullified.
or intended to favor
On
someone.
23rd, they have invited fresh tenders. People have submitted their bid. And in between on 28th, they have issued arrived at a settlement with you. On the face of it, it is nullified.
Because I have the highest value bid, I merged.
No, it may be. Once your tender bid was, this tender document was cancelled, how the court can, the authorities can consider that bid of a cancelled? Otherwise, we don't find any merit in this case. If you want, you withdraw this and file a review petition.
So the review is concerned, no time, my lord, because it's going to be expired on 29th February. Because Lani Single just directed that complete the process by 29th February. After 29th February, my lord.
Be happy with this order. Okay. Why this intra-court appeal? Challenge is laid to the order dated 29/1/2024, passed by the learned single judge in WPC number 5935/2023, whereby the learned single judges allowed the writ petition filed on behalf of the respondent
789.
And has cancelled the settlement arrived at between the respondent number
7.
between the appellant and the respondent number 7.
No, my lord, I'm the respondent of the interpretation. That respondent number 7
Here
presently
you are appellant.
appellant before your lordship. Yes.
Appellant and
Respondent number 7.
which is the authority arrived at the settlement?
Respondent number 2. By
Respondent
order dated 27/6/2023.
between the appellant and the respondent number 2. And has issued a direction to the respondents to initiate fresh tender process for selection of settlement of the market concern within a period of 1 month from the date of passing of the order. Full stop. Learned counsel for the appellant has submitted that as a matter of fact, the tender process initiated wide notice dated 23/6/2023 has already been cancelled by the district. Which authority is this?
The respondent number 2, my lord. Number 2.
By the
Respondent
number 2.
Respondent number 3, standing committee.
Respondent number 3, tender standing committee, respondent number 3. And therefore, there is no illegality in the action of the respondent number 2 of accepting the bid offered by the petitioner in response to the tender notice dated 2/5/2023. Full stop. It is noticed that no such argument was advanced before the learned single judge by either of the respondents therein, including the appellant. The learned single judge has recorded a categorical finding that there is no material available on record as recorded as categorical finding that
Settlement was awarded on the basis of cancel.
the settlement was arrived at on the basis of a cancelled tender notice. And the tender notice dated 23/6/2023 has never been cancelled. Full stop. In view of the fact that in view of the above, we don't find any merit in this appeal. The same is therefore dismissed.
Obliged.
There was a caveat in the.
Career discharge.
Item 44 for hearing.
Please, your lordship.
Last one.
Page 182 is the judgment, my lordship.
Both sides ready?
My lord, actually, I am not feeling well today, my lord. If my lord can.
Stays operating.
Stays operating in their favor, my lord. My lord, a short accommodation on next week.
I don't have any objection. Maybe allowed, my lord, because we could. Interim, maybe.
Interim order limited. Is it limited?
Yes, yes, my lord.
Yes, my lord.
I don't think so. It is limited.
No, until further order. It will be, my lord.
Meanwhile, the direction of the shall remain state until further orders.
Yes, yes.
Matter is adjourned at the request of the counsel for the respondent.
My lord.
List on so and so, respondent number so and so. List after 4 weeks. Check.
My lord, a short date, my lordship.
6 weeks.